have 25 participants. So if not more are joining, then we can start here. Okay, fine. So meeting is being recorded. Welcome all. This is a session. I think today it's 6 hours. So 3 hours I'll be taking. First 3 hours we will try and cover the CIRP and liquidation, which is I'm sure all of us are practicing in that field. Second session, you will have CIIRP and the new things which are being introduced. How well they will
I'm
come.
sorry to interrupt you, sir. I'm sorry to interrupt you, sir. There is an echo. There is an echo in you.
You are not able to hear me?
So there is an echo.
Audible, sir.
Anjali ji, is my voice echoing?
No,
So,
your voice is audible. I think there is issue with the participants side.
okay. Uh, Parminder ji, I think there might be a echo issue on your side if you have enrolled with the
But
two.
sir, you can log in again after logging out.
Just try once,
Can you
otherwise
please
I'll use the
check it?
earphone because earphone for 3 hours they create problems. So that's why I'm trying to avoid. But if your problem still continues, I will use them. Okay. So this amendment, I'm sure by now you all must be aware because it came on 6th of April. It's been 1 month, and during this time, enough of discussions have happened. A lot of platforms we have discussed it. Still, if there are some people who missed it, wants to discuss, wants to learn more about it, because now it's about to come, right? About to come means because it's been 1 month. Regulations were, they came out on 16th of April after this, right? Uh, IBBI has taken feedback. They're compiling in the regulations, etc. We hope that it will come within this month. That's the plan. Hopefully by before 10th of before 28th May it should be here. But let's see what is gonna come. So it's not yet there right now. Whatever we have been doing, we will continue doing that. What is going to happen and what kind of changes? See, CIRP was working for 10 years. It's not that CIRP or liquidation, it was not working, right? See, double IRP is a new animal, but CIRP and liquidation, since we have been working fairly settled, there were only few problems which were seen, and this amendment only takes care of those changes. Though we are calling it 2.0, IBC 2.0 and all. Uh, in my view, these are more of enabling provisions in liquidation as well as IBC, as well as CIR. So let's see what all it happened. Uh, I have 37 pages. Obviously, I'll be covering till 53, which is our waterfall mechanism. Post that, it will go into the second session. So, first half of my presentation, I think I'll do IBC amendment, and second half of my own presentation, that is after 1.5 hours, will go into the regulations. See, regulations are only enabling what is changing, correct? So, first let's see what is changing, then how they will be implemented will come from the regulations. In between, if anyone wants to speak, please feel free. We can discuss it. And I guess by now you might have marked all your attendances. So if that is done, let's focus. Whoever can keep their video on, and especially if you want to speak, please do so. It'll look like I'm not talking to the computer only. So thank you for being here. Okay, we'll start it. Amendment Act, it can be divided into parts. Uh, Maybe CIRP liquidation will be, given right away. CIIRP might take, second round or third round, depending on how ready are we with the regulations. So, first one, short title, nothing of import. And I will tell you today from the RP perspective, not from the advocate perspective. Because for advocates, I have a lot of problems with the regulations and the way it is being designed. But as an RP, uh, I mean, I have not much quarrel about it. So we will today discuss from the RP's perspective. Fine. Amendment to section 3, nothing much, more of a enabling provision. They say registered valuer will have the same meaning as in chapter Companies Act. So this was not defined, now it is defined. Registered valuers which were empaneled with IPPI. Now this is one very important thing. This explanation, you are aware of rainbow papers, right? Where Gujarat VAT came into picture as a secured creditor due to Supreme Court judgment. Now, by this explanation, that security has been done away. They say government operation. So, security can only be created by an agreement. Like you give it to a bank, right? You give a security interest, or you can give it to OC also, a security, but mainly we give it to financial creditors. Here they say it shall not include a security interest created merely by operation of law. I hope this is clear. So suppose some act says that chit fund act has superiority and government has power over it. That will not work now. Though it was rainbow was watered down, etc., etc. But now in the code itself, they are saying operation of law will not create security. I hope this is clear to all. Then service provider definition has been extended where they say IP, IU, registered valuer, any other professional. This is merely, you don't even need to know this. Service provider definition has been extended. Now what happened? So whatever major changes have happened, I have highlighted them like this. So it will be easy for you. We don't have to read line by line of all the pages. Right? Section number 5 was more of definitions, right? Uh, what was happening. Now, in this case, they have segregated avoidance, fraudulent, wrongful trading, what it all means. So 66 is fraudulent and wrongful. Avoidance is 43, 45, 49, 50. So we knew it already. Here we are more of, so for the purpose of writing in the code itself, it is written. There is no change as far as your or our RP's life is concerned. There is a good change in this. And what change is that? It comes here. Provided where multiple application for initiation of CIRP are pending before the A on the insolvency commencement date, initiation date shall be so and so. Now there are two dates in insolvency. What is there? One is when you file the application, that is initiation date, and one is when the application gets admitted. Correct? So application gets admitted and moratorium starts, etc. Right? That is insolvency commencement date. And there is something called insolvency initiation date. Right? Same like personal insolvency, right? Your section 96 moratorium starts on the date of filing. That is personal insolvency initiation date it starts. Our moratorium doesn't start, but I hope you know the concept. So concept is when you filed it. Now, they are saying if there are 3, 4 already filed, then which is the initiation date? Then initiation date will be the first one when it was filed. The first one. Maybe SBI has filed and let's say PNB has filed. PNB filed after 3 months. But PNB got admitted first. In that case, initiation date will be what was filed by the SBI. Fine. Initiation date and why this will be important, I'll tell you. Why do we even need to know that? This is important because for PUFE transactions, now we will not be considering insolvency commencement date. Now we will go to ICD, which is initiation date. So that means if there are application pending for 2 years, then what used to happen? PUFE used to go out of the play, right? They'll say, oh, 2 years it was pending, everything is wiped off. What can an RP or a liquidator do? Now you will find PUFE from the date of initiation of CIR. Right? Not ICD, but initiation. That's the difference. I'm holding it little bit, I'm spending too much time here only for this purpose. So you know from when to calculate that 1 year of unrelated party and 2 year for the related party. Okay. Also, clause number 26 says mergers, amalgamation, demergers were there. Now they have added multiple plans can come and multiple RAs can also come. Multiple plans can come. So one person can give two plans also, isn't it? Maybe for separate asset, separate plan, and for multiple RAs can also come. Let's say, I'm just giving an example. It might be useful for real estate insolvency, especially. Let's say one person wants to take up only one project. Another RA wants to take another project. That is now maybe possible through this regulation. It's possible. Multiple plan, multiple RAs. That's what our clause 26 says as of now. Anyone any thoughts on this? Is it good or bad or useless? No? Okay. No comments is a good comment. So we are good RPs. We accept everything which comes, right? Okay. After that,
Sir, I have a question regarding the previous point of insolvency initiation date. This is how
man
a
who's
RP,
speaking, sir? Man who's speaking because your video I couldn't see. Mr.
Sir
Saurabh.
Saurabh Modi here.
Yes, yes,
Saurabh
sir.
Modi.
Yes, sir.
Sir, my query is that how a RP will know that how many applications has been filed and when these
Good,
were
sir.
filed.
Thank you for asking this question because I was surprised that we have 26 people and nobody asked me this. Because see, you being a true RP in this case, we are asking how do we find it out? Where it is in the process. So one way of finding it is all your creditors who are present, right? First you'll ask them also. You'll check on IBB. See, now IBBI, every application before we file, we give an intimation, isn't it? So IBBI also, so right now this modus is not there, but we can apply, maybe let's approach IBBI, ask that when was the initiation of against this CD? One way. Since that is not there on paper, it's only theoretically, I'm telling you. Practically, you will ask your COC members that if you had filed any application, kindly share the CP number. Another way is by the SIN number of the CD, you can find how many applications are pending in the courts. Because see, your NCLT can only be one bench only, isn't it? Your registered office bench. It can be only Delhi. So you can find on NCLT also uh, if other applications are also pending regarding the same. So two ways right away I can think of. Third way, maybe IBBI can give us
Sir,
assistance.
the issue is that I understood. I mean, currently there is no mechanism for this. The
Yeah.
only way is COC won't know because let's say there are 10 creditors who have filed, and out of that, who has filed the first one, he can be an operational creditor also who is not part of COC also. So that is the challenge. Second is, let's say if the case is not admitted till there, no intimation has to be given to IB. So let's say if I want to initiate proceedings against a company, the intimation doesn't go to IBBI.
It goes, sir. You cannot file without that. Don't,
Sir,
don't, don't say that, sir. It does go. I'll show you. I'll show you.
okay.
When you go to IBBI, you have to tell. That's what I'm saying. Right now, from RP angle, I'm telling you, as advocate, when we file, it cannot go without intimation. So even 94, 95, it has to go. See here, uh, when you file on IBBI, you have to intimation of application, you can see, right? So
Okay.
when you, so application of initiation, initiation of IRP, initiation of PPIR.
Got it, sir.
It goes, it goes. It's not that it doesn't go.
Got it, sir. I was not aware. Good
And
that I know this.
correct.
Got it.
And anyways, you can only work to the best of information available to you. Correct. So let's say you have three bankers, they had filed, you get that information, you work accordingly. If there is some application which is not in existence, you are not aware, we are RPs, right? We don't have to be God. We just have to know what is humanly possible. But initiation is informed to that.
Got it,
Okay.
sir. Got it. Thank you very much.
Okay. So we'll move on. Now it's, I mean, this is a very funny thing. We have a 14 days timeline to admit. So adjudicating authority
Sir,
will,
if I have a question on the
whoever
last
speaks,
point.
please put on the video. At least I can know whom we are talking to.
This is Harmeet.
Harneet. Okay. Ji ma'am.
Har,
Ji
sir,
ma'am.
on the last point,
Yes.
where you have written multiple plans also.
Yes.
So, we already have a regulation which is already there in place. My question is on that actually. At the
Correct.
time of EOI invitation, that is the Form G, in 36A, they have inserted a clause 1A. I'll read it for the benefit of all the participants here. The RP may, with the approval of the committee, invite EOIs for submission of plans for the CD as a whole or for the sale of one or more assets of the CD or for both. So that was
Correct.
already there since May 2025. It is there. I
Correct.
am not sure how many of RPs are using this already, but
Correct.
was it not the incomplete in itself, and was it not having uh, insufficient provision thereafter? How, in case COC permits you to sell one or more assets, for example, so how you would have done that? So in fact, this new amendment is enabling the entire procedure for that one or more assets ka provision, if I'm not wrong.
Uh, no, so where's your question? Whether that was
My
insufficient
question
is
is,
your question.
yes. So
Okay.
my question is 36A 1A, which is already there for a year,
So what is the need of
how
this?
that was practically possible? Because
Okay. I'll
you
try
could
and
not
answer.
have multiple plans at that time.
I'll try and answer your question here. Because in this case, you'll have to become an advocate that way, right? See,
Okay.
it was regulations. It was not there
Right.
in the act. Now it is coming in the act itself that this can be bifurcated,
Right.
which gives a lot of statutory backing because regulations are only enablers, isn't it?
Yeah, but
So now,
I found that to
yes,
be
ma'am, I'm coming,
incomplete
I'm coming. That's why I
already.
give you an example. There is a
Mm-hmm.
company in uh, Orient Developers. It's a real estate company. They have only two projects. One is in Jaipur, one is in Karjat, Mumbai. Promoters are same, but assets are completely different. Investors are completely different. One is at a very different stage, another one is at a very different stage. Do you think you can have a common plan for them? No.
Mm-hmm.
In my view, no. Unluckily, they actually came out with the common plan and they made a monitoring committee. Plan was passed. Huh? They came out with a
Mm-hmm.
monitoring committee, 8 people in that, RP, obviously two COC members, uh, and obviously more of home buyers were there. So 2 people from Jaipur, 2 people from Kharzat, RP, uh, AR, and the promoters. 8 people. Now, monitoring committee is fighting with them within themselves. They are now at NCLET. Why? Because X person interest will not match with Y person. In that
Mm-hmm.
case, it would have been any time better to come up with two plans. For me,
Right.
this is the plan for use. And again, as I said, we haven't seen many of these. If it's a single corporate, obviously there is no meaning of multiple plans. But yes, if you have two separate projects, two separate assets completely delinked, what's wrong in
And
trying?
and the balance sheets can be prepared separately for both of
Why not?
them, maybe.
Why not?
Hmm.
That's
Right,
why
right.
this merger, demerger, amalgamation, all this is allowed.
Yeah. So thank you. Yeah.
Not many people use it. Yes, maybe because it was only in regulations, but since now it is in the act, let's try it as RPs. It's good. So see, again, all these provisions are enabling provisions. Please don't think that you have to do multiple RAs. You have to do multiple plans. No. Whatever you are doing so far, continue doing that. But if you feel like that one project is X, one project is Y, totally unrelated, they will not agree with this person and this person will not agree, please try multiple plans, multiple RAs. Fine. Okay. So with this, and again, this is omitted, that is omitted, doesn't really matter to your life. We have a an obsession with the fastness, in IBC. So we say that within 14 days, application has to be either admitted or rejected. Uh, Practically, what will happen actually doesn't really matter. And for RPs, it really doesn't matter right now because our role comes after the admission. So far only advocates will play. But what does AA has to check? Only three things. They say you have 14 days. In 14 days, you can't see much. Whatever you can see is if default has occurred, if the application is complete, I mean, debt and default was there above the threshold, application is complete, and no disciplinary proceeding pending against if the RP is proposed. In that case, admit it. Simple. And you reject only when there is no default, it's incomplete, or RP is not qualified or already has more than 10. Very simple, huh? It looks so cute on the paper. Default has occurred, application is complete, RP is clean, right? Okay, go ahead. Also, you give 7 days to rectify the defects. If they rectify it, you admit it. Good thing is they say, obviously, record the reasons if it is not done. Here, by way of explanation, it is explicitly made clear that no other ground shall be considered. No other ground. Only these three. That default is there. Simple. क्यों हुआ, कैसे हुआ, war हो गई, nothing. Debt and default, application is complete and RP is clean. No other grounds can be accepted. Again, for removal of doubt, it is hereby clarified that where a record of default in respect of a financial debt is there from IU, that means ROD is available. ROD is in Form D, which comes from IU. ROD is available, it is sufficient to take a call. No need to get into other considerations. Now, where will natural justice go, etc.? I'm not aware, but so it says ROD is there, simply admitted, that's all. It is considered, it shall be considered sufficient. No other questions asked. So these have come through the amendments. Now this was in section 7, right? Uh, Now comes section 9. In section 9, they are saying such other information. So again, any other information instead of such other information, again, enabling more of uh, legal language doesn't really matter to RP. Following provisions are inserted that within a period of 14 days of the receipt, they shall record a reason if they are not admitting. So NCLT पे pressure है to admit it, not on us. 9 में there are not much changes. It only says admit within time. That's all. And for section 7, they say ROD is good enough. No other reason has to be checked. In section 10, there is a major change. right? 7, 9, 10. 10, there is a major change. What it says? What does it say? IRP cannot be proposed now. So far, section 9 and 10, we used to pay 25,000 and propose an RP, right? That with the application. Now, IRP proposal is prohibited. You cannot propose. It's not optional like section 9. It's prohibited. It cannot be proposed. Obviously, when IRP can't be proposed, then no disciplinary proceeding pending, etc. will be omitted, right? Any other, all these are omitted, as you can see here, right? This one, disciplinary proceeding, nothing has to be seen, right? And 14 days again, you have to admit or reject, whatever. What they have more done, so it's not written in the section, but what all information they will be giving, etc., that will come through regulations. So we will learn that how section 10 has been made little more challenging, but that is through regulation. In the act, it doesn't say anything. Act only says do not propose the IRP. That's all. That is the only change. Okay. After that, section 11 doesn't really matter to you. Okay. 12A matters to us a lot now. We have seen cases where, if they were ex parte, cases were getting withdrawn within 2 days, 3 days, anytime, right? Then came our Byju's judgment, Glass Trust, that said there will be only 4 periods. Four before COC, what will happen, after COC, what will happen. So all that sections were made. Now it has been made very clear to us. 90% has been retained. No problem on that. They say that section 12A can be done only between this period. Only between Constitution, COC Constitution and Form G publication. Only one window. That is, when do you constitute the COC? We constitute the COC on, say, 30th day, isn't it? So 5 days for 3 days for publication, 14 days for invitation, etc. Right? So 30 days, let's say COC constitution, and Form G is normally published 60 days. Let's go with that, right? 60, 65, 70 days, right? That is the only window. Otherwise, everything is gone away. No after that, no post that. And it says first publication. Huh? Maybe first one might have failed. You redo second. Then what? Nothing doing. Only first and second. That's all. So वो था ना कि एडमिट होने के बाद सेटल कर लेंगे एटसेट्रा एटसेट्रा ऑल दैट era has gone now. Now we only have, please remember this, important as an RP to understand COC formation. Yes. Form G publication, right, is over. Now how NCLAT will do, yet to see, right? So we'll see how it will come there. But as far as law says, it says don't interfere. Uh, but if it is wrongful initiation, then what will happen? You tell. That stay will continue, isn't it? But 12A cannot happen. If Form G you have published, 12A is out of question. Fine. So 12A is a major change, like 10A, proposal, no proposal, and 12A is between COC and Form G. Section 14 is our moratorium.
Sir, just to clarify this thing, uh, what we are saying here is that before constitution of COC, 12A is now not possible, and once COC is constituted, then 90% is required to have this withdrawal. Correct?
90 was earlier also, sir. Yes.
So before, COC constitution, now it is not applicable. Not.
Yes, now it is not.
Okay. Okay.
I personally have done 4 12As, one after liquidation, one in 2 days, one in 3 days. But now those eras should be over. Right now it's there. If somebody is settling, ask them to finish it, this month only. Otherwise, it's going out of the
I
question.
completed last month only. That's why I asked.
Then it is okay. So if I'm saying if something is in pipeline, please finish it. Otherwise, it will not be into picture.
Got it. Thank you.
Okay. Now we'll come to section 14, which is our moratorium. Uh, Moratorium was against us, everything will stop. Correct? That is moratorium. Any problem, case, etc., will be deemed stay. That is our principal section, which is moratorium section. In this, again, you see, as an RP, you don't have to remember in subsection 1, 2, 3, 2A, all that, just forget it. What you need to remember is what I have written in the red here, okay? It is clarified that surety seeks to initiate or continue any action. Now, can that be allowed or not? So what was happening is, let's say if somebody has given a surety, he'll say the main debt, there cannot be any, there is no possibility of continuing any suit or initiating any suit. So debtor or the guarantors were saying that how do we file 94, 95? Because it was the same debt. Because of the same default, I can't initiate. If I cannot initiate, how will my 91, 95 will be taken up? So this is again a enabling provisions where they have explained that this moratorium will not apply on the surety or if something is happening with the corporate guarantor. Right? It's more of an explanation. I hope if anyone has question, please ask. Otherwise, we'll move slowly. So, and subrogation right is any which way is not there. Subrogation is if I have paid money on your behalf, then you are supposed to indemnify me. Correct? So that indemnity will also is not there. We knew it was not there through a lot of proceedings, through jurisprudence, but now in the act it has come that indemnity also is not there for the guarantors. So this was about 14. Not much changes because it was any which ways all encompassing, right? 14. Okay. Now comes section 16. Section 16. They say only section 7 is the place where an RP can be proposed, right? Is mandatorily needs to be proposed. So they say whichever RP is proposed in section 7, same shall be introduced and same shall be allowed if there is no disciplinary proceeding. And obviously they have removed that section 10 wala part, which is here. That 3A says where an application for the CIR, where an application for the resolution is made under 10, A shall make a reference to the board for recommendation, etc. Right? Now we know that recommendation doesn't go, it picks from the panel only. So section 10 application from panel only, mandatory. Okay. So if you're talking to any of the promoters and you are proposing, please do it ASAP if that's how you want to do it. Otherwise, this part will also go up. After that, section 18. What is section 18? Anyone remembers? Duties, right? So now, so far, we were saying RP will not accept or reject the claim, right? Everywhere we have learned that. We were saying we were glorified. It's more like a glorified clerk what RP was doing. Collate the claim. And collate means don't reject. जो आया है उसे रख लो. And obviously, if जो आया है वो रख लो, you make COC accordingly, and which creates trouble. Now they say very clearly, shall verify, and if required, determine the value. So whatever you are doing in liquidation, now you do it here. Now you cannot hide behind the fact that I am only collating. I am not deciding. You will have to admit or reject. And if you have admitted, obviously they can challenge it in A, and accordingly you place that person in COC, not place in COC. So far, we all know what the practice was. We keep them as contingent claim and put them in COC के जो होगा resolution plan में देखेंगे, right? Let RA decide. सबने सब कुछ उस पे छोड़ा हुआ है. We don't take any decision, right? But now RPs are supposed to clearly admit or reject. Obviously, you can ask questions, you can ask clarifications, etc., etc. But no more collation only. Verify and determine. Okay, that has come up here. And why this has come up is because it has gone away from the liquidator. Now, liquidator doesn't have to do. किसी को तो करना ही है ना. या तो liquidator will do or RP will do. So far what was happening, RP is admitting, liquidator will change it. What will happen? An IA is ready. They will say, sir, one insolvency professional admitted, another one rejected. So this anomaly was there. This has been changed. They say at the RP stage only, admit or reject. Fine. That was 18, which is duties of RP. Section 19, we know, is cooperation from the erstwhile management. Correct? Cooperation means, again, it's more of a word. Personnel means any employee. Now they say anybody associated with the company, which is persons. So CA, CS, all those people will also come into picture. That's all. It's again an ennobling provisions. We were filing 19.2 accordingly. Now it is cleared in the act itself. That's so not much of a big difference as far as our life is concerned, but personnel has been changed to person. Okay, which is a major change. Now in section 21, after the principal act, so in the principal act itself, 21 is COC, etc. Right? What is 21? I just said COC, right? Committee of Creditors, how we will treat them. It says COC, whatever was in CIRP, will continue in liquidation. Same COC. No more SCC. So in SCC, what used to happen? Other stakeholders also used to come, right? Operation creditor will also come, government will also come, right? In fact, in my view, even the shareholders, those preferential shareholders, those people could also come because they are also stakeholders, isn't it? So they could also come. Now, no more. So OCs को completely dead कर दिया है. Now OCs do not even have a say in SCs. So there is no SCC. COC will continue as it is what was happening in CIRP. Only the process change, people say. Now, where the liquidation process is initiated, COC constituted under the section of 21 shall also supervise the conduct of liquidation process. Right? So, one difference what it makes is earlier, liquidator could take a decision different from the view of SCC. Correct? You had a power that if you don't agree with them, you can decide what you want to do. Now that is not possible because now COC has come into picture. In fact, Anil Kohli ji is coming in the second half. He is a liquidator in one of the matter where this was a big challenge which is going on, Tech Pro. So where liquidator went against SCC and won some 1,000 crores for this SCC. SCC was not looking for it. SCC said, no, don't go for it. But liquidator took a different decision, went ahead, by God's grace, won also. Maybe but it was a gamble, right? So since it was a gamble, now our act itself says, sorry, no independent decision of insolvency professional as liquidator. Whatever COC says, you have to follow. So I don't know, it has come because of that or which action, but this is there now. No more independent decision, please. Also, voting rights will remain same. What was in CIRP, unless there is change in the claim or something is settled, etc. Right? Or if somebody is exercising section 52. right? They want to, you know,
So this existing STCs will continue or they will also get dissolved?
it will dissolve. Yes. So it's coming here. So your question is here, sir, with immediate effect. So I'm coming there, sir. So liquidation, COC will continue. For new cases, there is no problem. What happened to explanation is there, sir. Liquidation process initiated after the date of commencement of this. Also, ongoing liquidation process of a CD as on such date of commencement where liquidator has not made an application under for dissolution. COC shall continue for the remainder period of liquidation process.
So in
So,
that case, STC will be replaced by the COC when the act will become effective.
correct, sir. So liquidators have to take care that whenever it is announced, you get into this mode. Fine, sir? Okay. Next comes section 22. What is section 22? Appointment of RP. So appointment of
Sir,
RP.
sir,
Yes.
in this, we are saying that where the liquidator has not made an application under section 54. But what
54
if
dissolution.
what if A themselves says that now the time period is over and as the resolution has not been made, now company goes into liquidation.
The problem क्या है sir?
Also
54 is,
in
you know what is 54? 54 is dissolution.
yes.
It's not 33. I
Oh,
hope you're
okay.
not
Okay.
confusing it with
My
33.
my bad. My bad. Yes.
Okay,
What
okay.
is
So it's not 33, sir. It's 54. आत्मा को परमात्मा से मिलन, right? Last stage. So if you have already filed 54, तो फिर बात ही खत्म. फिर क्या करेंगे? But in all other cases, if you are doing a meeting with your SEC, don't do after the commencement. Do it only with the COC because SEC existence is over. That's what I'm saying. Okay. Now, one good change has come. It says in section 22, right now IRP is appointed and same IRP is confirmed in the first COC meeting, right? 22. It says if, let's say, you are deciding to continue with the person, if you decide to continue with the IRP, then what happens? Such person shall be deemed to be appointed as RP from the date of resolution, not from the date of AA approval, from the date of uh, resolution in the COC itself. And this decision shall be communicated to IRP. Obviously, the person needs to know whether I'm appointed or not. The CD, obviously, you inform directors and the board. Board means IBBI. It doesn't mean AA. There is no mention of AA. Is it there? So one IA is reduced in my view because Act says no need to file. Our regulation says something different, but those are draft regulations. I'm sure will be updated. Our regulation, this proposed regulation, still said that you have to inform what do you call the adjudicating authority. But adjudicating authority, how do you inform? You inform only through an IA. So this was not helping. That will go away. You only have to inform the board and please continue as RP. No need to wait for order of any AA. Fine. Okay. Now in duties of RP, there is a slight change, and that slight change is file an application to the AA in respect of avoidant transaction or fraudulent or wrongful trading. Again, this is not a change. This was there earlier. Earlier, they were only calling it avoidance transaction. Now, nomenclature is defined. That's all. So, for a practical purpose, there is no change. Whatever you are doing, you do now also. Fine. now it says, okay, now PUFEs were pending. PUFE takes 2 years, 3 years, 4 years, right? Now what happens if PUFE is pending? Will your resolution plan pass? So through regulations we introduce, through jurisprudence we introduce, but now in the act itself, by way of explanation, it has come that it is hereby clarified that the completion of CIRP or the liquidation process shall not affect the continuation of proceedings in respect to avoidance transactions or wrongful or those trading. So PUFE does not have impact on the resolution plan. I hope you are fine with it. It was there, and now it has come through way of explanation in the act itself. Section 28. What is 28? Anyone?
COC
28.
approval on certain
Approval.
matters.
Correct. Approval of COC. So far, obviously we need approval on most of the things from COC. Now it says there is another new section which is 28A. 28A is completely new section, and again enabling provision in my view. It does not impact our ongoing CIRPs in any manner. It's not कि ये करना ही है. It's your choice. If it helps, please do it. Now, what does 28A says? 28 says if the creditor of the CD or PG or some or corporate guarantor, if they have taken possession of an asset already, some asset through SURFACE, through any other provision, if they already have that asset, creditor may permit the transfer of that asset to the CIRP. Right? That should be no-brainer. If somebody wants to give their property in the common field, why will you say no? Isn't it? So 28 says, A says, same can be transferred to the main CIRP of the CD for the benefit of, resolution. Now, obviously, they will not send it for free. People, whoever is taking will not take it for free. All that, how they will do, who will coordinate, all that will come into regulation part. Right now, the section says they can transfer it. Now, obviously, if that particular company whose asset you have taken, if they are undergoing CIRP, then their COC will decide whether we want to send this asset or not. If it is individual creditor, they can decide. If they have not taken, COC is going on, then COC will decide. COC can decide by how much? 66%. Same way, if a PG is going or bankruptcy trustee is there, bankruptcy process is going on, 75% COC will decide. So it can be decided. Also, if somebody has not relinquished in section 52 and they want to decide on their own, they can do that. Again, enabling provisions. I hope. Any question anyone has or any suggestion, whether it's a good one, bad one, useless? No?
Here the draft regulations were not clear actually, so we had a lot of questions. But again, we'll have to wait for the final regulations for that.
Correct. So regulations are not very clear on 11A, how 11A will work. But Act says it can be done. If COC is going on, take COC approval. If COC is not there, the person can decide. Person means the creditor can decide if they have the exclusive right on it. Correct?
This creditor can put some condition while transferring the
Why
assets.
not, sir? It's your baby you want to sell for. Why not?
So subject to that only it can be put for
Obviously, it
resolution.
can be put subject to that only. Why not? See, मियाँ बीवी दोनों राजी होने चाहिए ना. Seller also, buyer also. In a way, they are seller only. Correct? And the buyer. So if they want to give it, they will not give for free. Now, obviously, that other COC will also have to accept it. You can't say, no, my asset is 100 crore, take it in 100 crore, put it in your books. Why will they take? So it's
That asset's value will go directly to that creditor. It will not come to the resolution plan.
depends. So if COC is going on for the other one, then it will go into the COC. If it is individual, and then obviously that plan value for that asset will have to go directly. Yes. So that we will learn in the regulations, because it's a new section. So new sections will have its own problems. We'll keep changing those regulations, etc. But right now the law allows for transferring. Earlier it didn't allow such things, right? It was developing through jurisprudence or pragmatic approach. But now the law says that yes, you can do it. That's the point.
It will be a part of the resolution plan, or it will not be.
It will be part of resolution plan only, sir. Who will give you money otherwise?
So it will come into effect only
Money
after
will
the
come
approval
from
of the.
resolution plan only, right? No other way. There's only one way to get money. That is a resolution plan.
So only after approval of resolution plan, this can fructify.
If somebody wants to give you before that, then please take it. Why will you not take it? But who will give you? If the company is undergoing CIRP, how will they buy that asset? Yes, if they want to buy, I don't know. I mean, good idea what you're saying. कि हमारे को आज दे दो, आप जितने मर्जी में बेचना. So if that comes, yes, good proposal. But sir, moratorium says you can't give it to one person in preference to others. All that thing will also come into play, right?
Money will come from RA only, because unless he pays the money, you can't pass on to the.
Practically, it will come from RA only, sir. Yes.
Yeah.
Okay, so this was allowed, and in PIRP BT, the COC can only pass it through 75% voting rights, so it will come through 70. Again, this is only about the assets which have been taken over already before initiation of this, right? But in my view, what stops you doing this after that, again, will not stop anything. So and again, in my view, personal, maybe different. This will work out only when you have common COC members. If they are not common, then it will remain a section. I don't know how many takers will be there for this. And why this has come? Any idea why this section should have come? This section, again, these are views only, right? So this section is, if land belongs to corporate guarantor, plant belongs to CD, and the raw material lying on the other side belongs to the personal guarantor. You cannot sell one without the other, right? In that case, you have to do it jointly, and that is why this section has been brought in. Then now there is a legal validity to such transfer and selling the assets together. Fine. Okay. Now comes section 30. Section 30 is our, what is our section 30? Submission of resolution plan. So submission of resolution plan to A, right? Now, in this case, what has changed is, we have heard of so many cases of dissenting financial creditor, right? DBS Singapore, Ruchi Soya, all those matters. We had, so people always calculate that if I dissent, then how much I will get, and if I don't dissent, how much I'll get. Some people were dissenting only for one reason, even if they were getting same value. You know why? Dissenting will get in priority to the others. But that priority was not defined, whether it will be 1 month, 1.5 months, 1 day, 1 hour, didn't know. So all those issues were there, and they were dissenting creditors who were thinking that if I go in liquidation, I will get delta X more than what I'm getting in the plan. So I might as well take this company to liquidation. Now this, amendment has taken away that also. Now there is no incentive to dissent. What they say? Payment of debt of the financial creditors who do not vote in the favor of resolution plan in a manner which shall not be less than the lower of the amount. Lower of what? Lower of what you would have paid in liquidation or you would have paid in the plan, under the resolution plan. So now lower of. Earlier it was higher of, isn't it? Now if it is lower of, why will you dissent? Dissent में तो नुकसान ही होना है ना. So you might not dissent. And now for RPs, I think it's a it's a welcome provision because now our plans will be approved with 100% majority. Now we'll not have to calculate 67 हुए कि 66 हुए कि 64 हुए. Now since there is no incentive in dissenting, if it is getting passed, it will pass with 100% majority. Fine. So good for us. Any question here? Anyone else? No? Okay. No question is a good question. Okay. Now again, these are enabling provisions, doesn't say much. What it says is implementation, while implementing the plan, that implementation agency when you make, you can make it with RP or any other IP also. Doesn't mean that same RP has to continue. If the resolution applicant feels that they want to propose a new RP, they can propose a new monitoring committee person. It was there earlier also through regulation. Now it has come into the main pact itself. Okay. So this was our plan which we were sending to. 31 is plan approval by what? By AA, right? So COC has approved. Now they have sent it to, let's say, AA. What happens in this case? So far, we give one plan. It takes time, whatever time, all the IAs are disposed, and then only plan is approved. Now there is an enabling provision which says the plan can also be approved in two parts. Plan can also be approved in two parts. If the COC says, because our internal problem is going on, first let's decide on the implementation and then we will decide about the distribution. Let's say distribution may take 5 days, 10 days, 1 month or so. We will decide that. On their application, if they have asked कि आप implementation first decide कर दें, then this, it can be done. So resolution plan can be passed in two stages. One is implementation, that who will take over the asset, and second one is how that money which has come, total kitty, will be distributed. Fine. Earlier, such option was not available. Earlier, such option was not available, and that is why all those IAs had to be decided first, and then only plan would have come. And that was creating a problem that even 2-3 years were, resolution plans were pending. In recent Supreme Court, you must have heard, right? 400 plans are pending, and when our NCLT president was appointed same day, that why so many plans are pending. This was another reason. And this amendment in 31 is another shot to shorten that period of resolution approval.
CD will be handed over once the implementation is approved.
Obviously, sir. So till you get the money, why will you hand over? Isn't it?
If the
So,
plan consists of deferred payment, so
no, so RP will remain in power, no? RP will remain in control. But the problem comes, the person between whom the dispute is there on distribution, they will not give handover unless they get the money, isn't it? But luckily, since RP has all those powers of removing them and they don't have any say, it's an see again, it's an enabling provision. It doesn't say कि two parts में ही decide करना है आपने. You can continue what was happening today. You can continue with same, no problem. But if you feel there is a dispute, there is a disconnect, then at least get the RA first. Let him start implementing, and we'll decide our indoor management later on. Our indoor problem will settle. Fine. Okay. Shall pass again 30 days time. That's our obsession. That will always remain. They say within 30 days you have to settle. And if there is any delay, please record reasons in writing. Not for you. Okay. One more good provision they have said. They say prior to approval, you used to have, you needed approval of COC. Now it says before the resolution plan is submitted to the A. I hope you are aware of it. Uh, suppose somebody has to take approval of competition commission. Now that approval, when that approval should come? So there are, you must have seen cases where they say it should come before submission of resolution plan or on the date of approval of or approval of COC. So right now the jurisprudence says on the date of approval of COC. Here with this amendment, it says before submitting to A also, if it comes, it's fine, no problem. That is what it says. That's all. That's the difference. Another one. This is new section 5 and 6, which have been added. Uh, it was there, people were following it up, but now it has come into the section. The section says if there is some license which is, suppose it's valid for another 3 years, that should not be discontinued. It shall remain the asset of that CD. It shall remain asset of the CD as far as it is, you're making payment for that. Any idea, any case law you can say about regarding this, which was in recent news? Is it Spectrum?
Regarding DJCA year license.
Correct, sir. So new that Spectrum license, which was discussed, where they said it's a public property, not the property of CD. So it is to take care of that. It just says if licenses were available, they will continue to be available as long as the payment is made for that during that period, not for the prior time. So again, though these are new, but more of enabling provisions. Only thing you need to remember is license continues if paid for during the CIR. Also, while approving the resolution plan, directors, promoters liability will not go away. It will continue. Remember, many of the promoters used to say कि जब plan ही pass हो गया, now main debt has been over, how can you initiate insolvency against us? So this explanation takes care of that. It says if regarding the main debt, debt against which guarantees are invoked, if that is settled, unless that is settled fully, right? If that is settled, that will not discharge you from the liability. And also no subrogation right. So suppose CIRP is going on and the bank has taken your, asset, which guarantor's asset, let's say it satisfied 20% of the liability. Now you can't say that 20% I have paid, so I will sit in the COC for my 20%. So that because you are related, and now in the law itself it says there is no subrogation, that you will not be. So the word they use is indemnification right is extinguished. Fine. Okay, that's all for the CIRP. Now we come straight away to our liquidation. So 33 is liquid. So 32A is remain there, nothing, no change. 31 we have learned. 32 is clean slate principle will continue as it is. Now, what used to happen? So far, we had 180 days, 90 days extension, another 60 days, 330 days total. And somewhere in between, we were playing with the exclusion part. So our law is still silent on the exclusion part. Let's see how that plays out after this. In my view, it will still be there. We still take exclusion. So we're still silent on that. One thing which has gone away is fast track. Now, there is no fast track corporate. So section 33 is you send the company to liquidation, right? 33 says fast track can be removed. This word can be removed. So it's not there. What else has changed? So far, learned liquidators here. The moratorium used to apply in liquidation or not? What was the status so far? No one? Liquidators here? No, no liquidator. Okay.
It was there in section 36, I think.
Section 36, there is moratorium. Where it is?
Legal proceedings were barred, I think.
No, sir, it just 36 is liquidation estate, right?
Yeah, I don't recall exact section, but legal proceedings during liquidation, they were prohibited.
No, sir, it was not there in the act. Now, in the act, it says moratorium applies mutatis mutandis, except 52. Like 52 still is there. 52 says if you want to take it outside the liquidation, you can take away. That's fine. So, subject to 52, a moratorium is there, and section 14 subclauses apply. So, practically, it was there again. I'm not denying through regulations also it came. But now in the act itself, it says there is moratorium. So everything is continuing if you see. COC continues, moratorium continues. If somebody wants to sell outside, it's fine. Otherwise, liquidation is done. So moratorium now applies in the liquidation through the amendment in 33, section 33. No, uh, so obviously this was easy. This is doesn't really hurt our thing much. What is interesting to know is, so far, if the liquidation order is passed, we were doing something called sell the CD as a going concern, isn't it? Why this was happening? This was happening because suppose one plan has failed, or implementation has failed, or RP has filed a wrong form H, because of which liquidation happened, right? Right? What happens? There was no chance to revive. Since there was no chance to revive, for the first 3 months, a new animal was born which said selling the CD as a going concern in liquidation. Now we fought like anything on that. We said, okay, if it is selling as a going concern in liquidation, will 32 apply? Yes or no? That went on into jurisprudence. Some judges says yes, some says no, some says yes, why not? Because it is going concern. All those problems cropped up. But this was mandatory because one fail chance doesn't mean life is over, right? Doesn't mean liquidation. So we were selling it as a going concern. Now the amendment says that if COC wants, if COC says that fine, there is a problem, instead of sending for liquidation, please reset the CIRP. It is possible. So this is second chance which we are getting, because they say once liquidation happen, then forget going concern, this and that. Simple. Keep it very simple. If it is not done, you reset it. Now, reset it from when? Will not reset it to IRP, isn't it? Plan. Why will we ask for Form A and all those things? They are saying you reset it to Form G. You invite again new people, try this process, and come back to us. Obviously, that should shorten, and that is why they say 120 days is allowed for the same. If 66% COC decides, they can apply for restoration of the CIRP. Fine. Obviously, there is a choice whether same RP will continue, they want to change. All that will happen here. That also is possible. But there is a restoration of CIRP possible that you need to know as an RPs.
At what stage this restoration will happen?
When the liquidation order is about to come.
After filing the liquidation application.
No, sir. Why will you file liquidation application and then file this?
Because at that time, there will not be any
Before that, right?
plan.
Why will you? It can't be after filing. So once liquidation starts, forget CIRP. Forget going concern. That's the
No,
whole
but
point behind it.
if the COC recommends for the liquidation, that application is pending in NCLT.
So then
So
why will they restore it, sir, if they have already recommended?
they have some in between some proposal coming through. So can they intervene and say that now take up for restoration?
Change of mind, sir. Abhi law does not say. The act doesn't say. But how what you are saying will play out in the market is, let's see. But the law doesn't allow that, sir. Law says once CIRP started, forget it. Just a sec. So normally that will not happen, sir. Restoration after liquidation is not possible. It is only possible before liquidation order is passed. Fine. And it will get reset to Form G stage. You again invite for resolution plans and you try one more time. 120 days is allowed for that. Fine. And explanation they have already said for the purpose of section. It is
So can we consider this as an extension?
this is more like an extension. Yes, this is
Because
only
only
like
one
an
extension is allowed as of
extension.
date.
Extension was allowed when you did not get a plan. In this case, let's say you have given a plan, implementation also failed, or let's say the plan was not compliant. In that case, you did not have a chance to reset it. Only option was in 33, send for liquidation. Automatic, isn't it? Now that thing they have taken care of, that once you can restart it. Even if there was a mistake, don't send it to liquidation. If COC feels, reset it. That's the whole point. And obviously it is with immediate effect. So the moment this is notified, these things will come into picture. Okay. Also, it says it can be restored only once. Huh? Not like खेलते रहेंगे 120 days, 120 days, 120 days. That is not possible. It's similar to our extension possible for one time. Same way, resetting also possible one time. Okay. Another good thing, in my view, very good thing, that now you can straight away go for dissolution also. The law and the act itself provides for that. Earlier, if COC, even if there is no asset, I'm a liquidator in one of the company where the order records that it has 71 rupees and didn't file for liquid dissolution straight away because it was not allowed. So now that is allowed straight away. If there is nothing left, please go straight away for dissolution. No problem. So direct dissolution under 54 is allowed. Okay. Again, within 30 days, it has to decide on these applications. These are won't concern you, but it has to be there in the act, so it is there in the act. Now comes, let's say, okay, this is going to impact all of us, which is Section 34 of the Principal Act. It says RP will mandatorily be changed. RP cannot continue as liquidator. Mandatory. Shall is the name of the game. So if you are thinking you will continue, there was a circular, right? Everybody knows. Few years it came into picture. Some NCLTs were following, some not following. Then NCLAT said, no, don't follow. Circular has no meaning. Now, because circular had no meaning, now it has come into the act itself. RP will not continue. COC will continue. Same COC will continue. But RP will not continue. A new person will have to come. And as per my reading, liquidator cannot be proposed also. Anyone thinks differently? Can the liquidator be proposed? Amit ji, any opinion if she's here?
I think the COC can recommend the other IP as a liquidator.
You think they can, right? Where does it say that, sir? It simply said where the AA passes an order of liquidation under 33, it shall refer to the board straight away. There is no if and but.
No, but in the
COC may not be able to initially recommend, but later they have a power to replace. That is the plain reading of it right now.
Correct. No. So that's reading also.
the name suggested by the COC that can be referred to the board for recommendation.
Act does not say that, sir. That's why I'm showing you the act right now. I'm not. So I haven't made presentation for this particular reason only. No word is added or removed. It's very simple. It says liquidator. Again, my opinion, it cannot be proposed. And I do agree with Harmeet. Plain reading says cannot be. Yes, they can replace. That is fine. That is coming up now. Notwithstanding anything contained in this section and section 34A, an insolvency professional appointed as RP of the CD under this shall not be appointed or replaced as the liquidator. So RP cannot continue or come back. ये नहीं कह सकता कि चलो ठीक है कर लो हम 1 महीने बाद वापस चेंज कर लेंगे. Isn't it? So if COC is with you, this was a loophole, isn't it? आप कर लो बोर्ड से अपॉइंट.
Same RP cannot continue.
Same
COC
RP
can appoint another.
continue or come back.
Sir, what if
Yes.
the application for liquidation, maybe the resolution for liquidation when it is being passed at the COC and they recommend the name?
Exactly.
Will the
So in
NCLT
my
not
view, it
consider
should
that?
not be recommended because it doesn't say anything. Where does it say?
But it is not prohibited also.
It's not
They
allowed.
recommend some name who is not the RP. Let's see how it goes. I think
I
they
hope
can.
it gets clarified through regulations. Act says it should not be.
It is for the adjudicating authority to decide whether to consider it or not.
No, sir. It doesn't say may. It may refer to the board. It says it shall.
But earlier also, there were so many provisions which are not practically being implemented. They had to take a reference from the board every time for an appointment. That is not being followed. And those sections are still not removed.
They take recommendation. How they do it is see, even the court does not talk about panel. Where is the panel in this court, right? But we all know we are using panel because IBBI is saying we'll save time on that. So that is only for practical thing. But when it says it shall refer, it only means one thing, that proposal cannot come.
I think if COC decides in the last meeting while regulation 39 and all of the CRP regulation is the cost, the liquidation costs, etc. are being decided. So name can also be proposed therein.
COC has the power to replace. No? So if it
COC
recommends
has
that,
got to
then it
replace.
requires
If they don't like it, let them replace.
So ultimate authority is with COC.
Oh, yes, yes, yes. That is
Yeah.
there. I do agree with you what you're saying. That after 1 week they say we want to change, then can NCLT say no? They cannot,
Yeah.
right? So
No,
it is
but the
up there.
same RP cannot come back.
Yeah, that is for sure. Same RP
Okay.
who was RP once cannot come back here again. Fine. Now, I don't know that RP, suppose that RP was replaced, can that replaced RP can come? Now, all those things are too much of detail, not yet there. In my view, both of them will not come. Whether IRP can come, we don't know. So, those things are left in.
That IPE can come where that
Exactly,
RP was the
exactly,
member.
exactly. That's the whole point, sir. If that RP cannot come there, it's on IPE can come.
Too many
Right now,
questions.
right? Okay. And as we were discussing, COC can replace at any time during the liquidation process. COC is of the opinion if they resolve to replace. It says they resolve to replace. And that is why, you know, if COC is hell bent कि हमें अपना liquidator लाना ही है, and as Miji was saying that if they replace, why will NCLT say no? Unless they are too reading it too fine, they will allow that same liquidator. That law is silent on that. COCs can replace. Now, powers and duties. Power and duties. Now, liquidator does not have to do what he was doing earlier. And that is why they have reduced the fees also by 50%. They say, our so earlier we were supposed to make that list. We were supposed to identify how much is due, how much is not due, decide. Now we just have to maintain an updated list. Same list which was maintained by RP. We just update it. RP भी update करता है, you continue the same process. Now, obviously, you don't have to invite claims. You invite only those claims which were not admitted during CIRP. So there is a chance of coming, or if somebody wants to update or revise. That's all. So that part is gone. Now you only have to keep the CO because see, there is no SCC now. Remember, you have COC. COC was there in CIRP also. Same COC is continuing. So there won't be much of a difference in terms of your work as far as COC is concerned. And
Updating means so he has to add the interest and then make the.
no interest will be added, sir. That's what. So now they say in liquidation also as on the date of insolvency commencement date. So कहाँ से add होगा sir?
You take 2 months, 2 years to get for liquidation. That part
It's
will.
5 years. What can we do? It says on insolvency commencement date.
What does it mean by updating then?
Okay. What it means by updating? Updating can. Why do you think updating can only be up? It can be down, isn't it? Suppose they have recovered something in PIRP or bankruptcy trustee, they will reduce it down. So updating can be lower side also, right? So in my view, it will be lower side only. Because how will you increase it? If it is on
Yeah.
the insolvency commencement date, how will you increase? It can't increase.
The liquidator should have the knowledge of those developments. Then only he can update that.
Which development? So,
Suppose some other payments are made during the period or
no, they have to file it, sir. If they're not filing, let it be. What can you do? You are asking them to file. They will file if they have. So it is the COC's duty to change it. It's not your duty to find out how much they have recovered or not. See, anybody who has paid, they will inform you any which ways. Don't worry, it won't happen that somebody double dipping is there. Double dipping doesn't happen in our system. जिसने दिया है वो बता देगा आपको आके और ईमानदारी से तो that same creditor should tell you. If you feel the creditor is not telling, somebody will tell you, right? And obviously, because of this, since we don't have to verify claims, etc., all these sections have been done away with. 38, 39, 40, 41. It was consolidation, verification, admission, rejection. These sections have gone. Now you
So
don't have.
new claims will not be received, but
New claims will be received, sir. If somebody wants to file, they did not file, they missed in the CIRP, they can file it. If they missed in CIRP, they can file it. Otherwise, why will you even give an newspaper advertisement? So that newspaper thing is still there, right? It is for two things, either update or new claim. If it was not filed, you missed somehow, you can file now. Practically होगा कौन सा जब CIRP में नहीं फाइल किया अभी? Why will somebody file at the liquidation stage? But it is allowed. Okay. Now comes the PUFE thing, right? We said no, from initiation date. So initiation date and ending on the insolvency commencement date. Earlier it was insolvency commencement date. Now that is not there, sir. Now it is initiation date and ending on the insolvency commencement. So your PUFE period will be from initiation date. And initiation date will be same what we were discussing earlier. First application which was pending was filed. That is our. So now PUFE determination is more trickier now, right? Now you have to even find कि किस दिन हुआ. अब तक तो it was easy, right? The day we get the order is the ICD. And now you have to find the initiation date also. So initiation date has become important that you need to take care of for filing 43, 45, 46, 40. This is another change which they have made. One change is, let's say RP is of the opinion that I will not file. And liquidator also, let's say, doesn't file. But a creditor wished to file. Earlier creditors didn't have that option. They had only RP could file it, RP or liquidator, isn't it? They had to make opinion, forensic auditor, etc. Now the amendment says a creditor either by itself or jointly can file this application. And if it is proved or, A thinks कि yes, RP should have filed it, why they didn't do it, and if they find merits in this, then what will happen? You know what will happen, right? That will go to they will pass an order requiring the board to initiate disciplinary proceedings. And it doesn't say it may pass, huh? It says it shall pass an order requiring the board to initiate disciplinary proceedings. So अभी PUFE फाइल करनी है कि नहीं करनी है? Now you know the answer. There is no reason not to file, no reason to hide things. Please file it. If you feel there is any iota of doubt, it should be filed.
And POC will decide what is the PUFE transaction.
No,
Yes,
in fact, this was already there, but was limited to undervalued transactions only.
correct, correct.
So that has been now corrected. This entire thing was already there.
No, but this was not there, that such transaction and adjudicating authority shall pass an order. All these was not stringent.
Yes, that was
Now,
there, sir. I'm just reading that only because I also had a doubt. They are requiring the board to initiate disciplinary proceedings against the liquidator or the RP for
they
section
was right.
45 and 48. Yes, that was there in section 47. But that
Oh,
was only limited to undervalued transactions. I think this is now
now it is for
corrected.
all
All of them, yes.
43, 45.
So an
50.
application could have been filed, can still be filed by the creditors under 47.
Either alone
And the
or in conjunction with.
AA shall pass an order requiring the board to initiate disciplinary proceedings.
So RP cannot have different opinion from COC.
So see, in
Yeah.
SCC he could have, but now since SCC is not there and COC is continuing now, there is no option. Now that person will also uh, is bound. But now, Harmiji, you think COC has a decision or RP still has a decision to file PUFE?
I guess
RP has a responsibility to file. COC is entitled in case they have a view different from the RP. They can go ahead and file against
So
even the
RP
RP.
can have a different opinion?
That's the point. If RP says that
At the
he
cost
doesn't
of
find
fighting it with IBBI at the end of it, we can have.
that means COC's opinion will prevail in that case.
So better not to fight, right? What's the use of fighting?
Yeah,
Right.
then ultimately you'll be fighting with IBBI on why you didn't file.
Absolutely. So filing may save you, but non-filing will definitely not save, right? So better to file. So I think takeaway is don't hold it. If you have even ever of doubt, please file. Now, what has changed is this only. 2 years preceding what? Preceding initiation date and not the commencement date. Only this thing you need to remember. I'm sure PUFE we were all filing wherever there is any apprehension, it was getting done. Only thing is look back period will start from which date. That's all you need to. And they say within 14 days, blah, blah. Okay. Now we come to section 52. Section 52 is our relinquishment of the secured creditor, right? So a secured creditor, if they don't wish to be part of that COC, they can do what? They can sell their asset on their own, right? So they could sell it. I think till now it was 30 days. Now it says within a period of 14 days, they have to tell whether they want to relinquish it separately or not. Fine. If they want to do separately, if they want to relinquish, they don't want to relinquish. Only the unsecured part they will sit in the COC and secured part they will be out. And they will contribute in the liquidation. How much they will contribute? Amount of insolvency resolution process cost, liquidation cost, and workman's due. They will be, because they were pari passu, right, in 53. So they will pay these three costs: insolvency resolution, liquidation, and workman due as referred in the clause. They were still doing. Some creditors were, arguing in NCLT saying, why shall we pay to the liquidation when RP has not even lifted a finger? Why shall we pay that person 4% or 3%? So that was usually the contention. But right now, I don't think there is any ambiguity. Law is clear. It says you have to contribute for these two things. Fine. And if they are not able to realize, then what happens? If the secured creditor is not able to realize, then what will happen? Then it will come to liquidation estate back, right? After 90 days. So then we will sell. As a liquidator, you can dispose it off. 53 is our waterfall. It only thing is, so it was earlier, it was in practice. Now it in the law itself, it says the secured creditor is secured up to the extent of the value of such security. So I can't, one person has a car as security and another one has a cycle as a security, cannot say they are equally secured, right? So anybody who has cycle ki security, they will be secured only to that extent. And if somebody is more prudent and they have taken good security, they will be secured, uh, they will be in a better position in this case. And again, 2 years preceding the liquidation commencement date, they have to take. Okay, this one I think might be important.
But
So
this priority of the charge is recognized here in case of secured credit. First charge, second charge.
So first charge, second charge, again they're silent in a way. They didn't use that word first charge, second charge. Here they just said, provided where more than one secured creditor has any security interest over that asset. So this is where that first charge, second charge kind of thing comes into picture. No secured creditor shall be entitled to realize its security unless the realization is agreed upon by 66%. So, first charge, second charge, I think will be taken care by this proviso that if there is one more than one, then it will be decided by 66% voting share between them.
If the second charge holder has more percentage of voting, so his say will prevail.
Will prevail. So
So that is not recognizing the.
I do agree, sir, to what you are saying. I appreciate, but this is what the law says, sir. This is the new amendment, and plain reading says first charge, second charge. It doesn't even. It's not even mentioned. Yes. It only says if you have more than one is one first charge, second charge, right? So they will go through this process. And don't know how will they decide in 14 days. That's another beauty. If they don't decide in 14 days, then it will come to liquidation estate any which ways. Right? Up to the value of security it has come. And okay. And they say that if there is any other contract contrary to that waterfall, such contract shall be disregarded. There is no whatever is written in the code shall prevail. 53, is our dissolution only. One major thing which has changed in liquidation is instead of 1 year, now the time period is 180 days, not 1 year. So they say now work has reduced, finish it faster. Within 180 days, you do it. If you're not able to do within within 180 days, one extension for 90 days is possible. 180 days plus 9. So same like CIRB, as it is now in liquidation. 180 days plus 90 days.
What
Also,
happens if it doesn't get through the next 90 days also?
then assign them to your COC members and file for dissolution, sir.
The POC members should be agreeable for that.
I know, sir. Uh, So, see, practically, we all know, right? It's been 10 years we are playing with this act. So, what is changing? We can only discuss today what is changing. And this is what is, what the new law says. Again, PUFE transaction wrongful trading will not come into the way of 54 because it can be transferred to that person. And if there are proceedings going on against against the company or the CD, then also COC can decide whom to replace, who will take care of those proceedings. Fine. And one good thing which has done away is earlier liquidator had to give an estimate of what is the cost, what are, etc., right? And then if there is a difference in the actual cost, then propose, then the reasoning, etc., has to be done. Now all those is not there. Now they say since COC is there, there is no need to give an estimate. Let it come in monthly COC meetings. Fine. So that part is also done. Other than this, our obsession, 30 days they have to, AA has to decide. How they will decide, I don't know, but it will be decided. So this was the amendment. I am not going in the other ones because that will come into the second half post lunch. Now I think we'll take a 10-minute break, and after that we will start our CIRP regulations and liquidation regulations. They look quite like 40-50 pages, but we'll not spend that much time. We'll need only 1 hour, 10 minutes or so to cover it up. Fine. So, Anjali ji, can we take a 10-minute break and reassemble at 12:55? Not right. Okay.
Yes, sir.
So,
Let's take a break.
Okay, so we'll all meet at 12:55 and we'll start with the regulations. Thank you.
Right, sir. Right, sir.
Okay. Are we back? I believe we can restart. I guess.
Yes, sir.
Okay. Ji. Okay. So we have covered our amendments, main amendments, because obviously amendments will not be changed, right? These regulations, these were draft regulations, right? They were basically discussion paper was there. A lot of people have given their suggestions. This should be changed. This might be, tweaked in this manner. Uh, Again, that is why this is not final. Many of these things will change. When they will change, 10 days, 15 days, we don't know. But what IBBA proposed as regulations, we will learn right now. So, and that is why, since they are not yet finalized, uh, there is, it's more of discussion. And that is why please feel free to hold me, stop me if you have any points to discuss. For next 1 hour, we will learn about what are the new regulations. And these new regulations are for what? To take care of the amendments which we just learned in the code. So first page is nothing, just to inform what is happening. These are the topics which in which we have divided the amendments. One is information to be furnished by OC. Now, information to be furnished by OC, RP has no role. As an IRP, RP, you don't have a role. As advocates, you will have role in that. Information to be submitted by corporate applicant, section 10, again, your role is not there. But what all they will be filing during section 10, that all is uh, proposed there. Manner for withdrawal under 12A directly impacts us. This we will deal in thoroughly. Manner of collating claims. Again, now this law has changed. Though they still says collating, but now it is verification also. Handling over of possession under 19. So 19, section 19, that person to personnel to person, sorry, that we will be discussing in detail. Deemed appointment of RP and its communication to IRP, CD, board, and A. So this A is by mistake they have filed, I think. This will go away because main act does not ask for that. Or maybe information can come into subsequent monthly progress report, right? There is no need to file special IA only for this purpose. Manner and transfer of assets of CD. This is that 28A section. Manner of payment of FC who did not vote, that dissenting financial creditor. Conditions for, so implementing agency, right? We said who can come, who will not come, who will form, who will have veto rights. All those things can be discussed here. Forms and conditions, etc., which will be, for implementation. So first implementation and then the distribution. So if we want to segregate them, how will we do that is discussed here. Manner and condition for restoring, right? Restoring of CIRP is important. So that manner, in what way, what voting right, when do they apply is also discussed. Condition for dissolution. Now we know we can go directly for dissolution, right? So how can we go there is discussed in 12. And release of guarantees in the resolution plan. Is that possible or not possible? Right now, is it possible? Release of guarantees in the resolution plan. Anyone? Is the release of guarantee possible in release resolution plan. It happened once, yes, many a times we did that. Is it happening these days? Anyone has recently passed the resolution? No? People haven't come back or nobody is doing liquidation? Okay. CPRs तो वैसे भी मिल जाएंगे सब. Okay. Fine. So public comments, blah, blah, blah. These are the topics. So these topics we'll discuss in detail. Information to be furnished by the OC. So now they say section 9, when you're filing section 9, all these information as may be specified by the board shall be furnished. Now, one thing which they have mentioned here is that all the relevant GSTR 1, GSTR 3B, and record of default from the IU can be produced and shall be produced for the section 9 application. So information to be produced, section GSTR 1, 2, 3 is obviously there, right? Nobody will say that don't do it. E-way bill, etc. all has to be to, authenticate your debt and the claim. But now they say IU also, if there is a default of IU, that should be mentioned. If there is any partial payment received, that should be mentioned. If there is any detail of transfer or assignment of operational debt, that should be mentioned. Detail of any guarantee provided by the CD, that should be mentioned. Statement of accounts of the OC with the CD showing, that should be mentioned if it has been provided. A statement whether the OC is a related party or not has to be mentioned. Details of any other proceedings, if it is going on, that has to be mentioned. See, if there is any other detail proceeding going on, then it automatically means that there is some pre-existing dispute. And if there is pre-existing dispute, section 9 will not happen. But let's say there is some check bounce thing which is happening, all that also will come into picture. Any other information that the OC considers relevant. So
This IU certificate is mandatory for OC.
So again, they're not saying mandatory as of now, sir. I'm showing you that. So IU certificate, how will an OC will file an IU before default is there? And otherwise, then everybody will be filing everything on the IU. So how will that be really operationalized is something yet to be seen. But they're saying if it can be, you file it on IU, you give section 8 notice. We are discussing that it will be coming. But they say preferred, yes. IU default should be there. And you know how IU records the default? They send 3 times the message that so and so is there, so and so is there. If nobody disputes it, then it is considered as deemed approved. But let's say if somebody disputes it at that stage, then will that be admitted? No, that
It's
will
a pre-existing dispute then.
obviously they will dispute it, right? Why will somebody not dispute it? The moment you send section 8 notice, everything is disputed. So, and it seems that section 9 application has become even more challenging. Section 7 is easy. Section 7 is somehow very easy, but section 9 and 10 are too difficult to get at. Same way in section 10, when you're filing section 10, then what happens? Then they say, I will use my highlighter. Yes. So Under section 9, they say if you can give IU information, very good. Otherwise, GSTR 1, GSTR 2, any dispute, everything you provide, detailed one. In section 10, what they say, and from RP perspective, this is very good. From lawyer's perspective, it might be a nightmare, but from RP, it's very good because section 10, now the new RP which will be appointed from the panel, how will that person will have information about the CD if they are not giving information right up front. So this is where this amendment comes into picture. It says information relating to the books of accounts and such documents. Again, that prescription word has been replaced with specification word. For your life, it doesn't make a difference. Now it says submission of information. What all information will be required while filing section 10? What are these? List of all the bank accounts, all the bank names, branches, who are the authorized signatories. Also, they say immovable property register, movable properties and inventory, investment in securities, subsidiary, joint venture, all the intangible assets like IPR, etc. List of receivables. So in a way, this was available in the balance sheet, right? Balance sheet supposed to have these, right? If the auditors report. But they say if it is not there, provide them separately and clearly. List of receivables has to be provided. Also, what all they need to provide? Detail of secured, unsecured creditors. List of all creditors with contact details, email address, and complete particulars. List of ongoing litigation, dispute, arbitration. List of all employees, designation, workmen. Particulars of subsidiary, joint venture, associate companies. Corporate guarantee given or received. Statement of transaction with related parties for the last 2 years. That means they themselves have to announce, okay, this is what we have entered into. Details of regulatory approvals, license, registration, everything. Organization structure, key MPs mentioned. Statutory compliance, filing of MCA, income tax, GST, provide. Details of joint development agreement, provide. Details of assets which are attached by ED or other agencies, that needs to be provided. Details of allottees along with their name, amount due, and units has to be provided. Such other information. So, see, concept behind is that let the person comes with clean hand, not just say that I'm insolvent and that's all. Let them provide the information first hand before even filing the application, right? Or at the time of filing the application. So do you think it will make section 10 more difficult or easier? Or now we'll not see any section 10?
It has
Anyone?
definitely become more difficult, sir. How to fight? Earlier, only the last, the financials, not more than 15 days ago, was a problem for most of the CDs. Now, how shall we prepare entire list of? I don't think we'll be seeing many Section 10 applications now. We are already distressed. Accountants are not there.
Correct. So this only means that section 10, I think it will be really tough to get any section 10 admitted, because if they are ready to give all this, they are actually surrendering to whatever blame we are going to put on them. Because section 10, you are not proposing RP. RP will come from panel. First day, they will start putting PUFE application the moment you give all these information. So, but that's what the stage is. Section 10, you will have to provide all these details before filing the application.
Basically, Section 10 application will be there for pure business failure applications.
Sir, even
I
now
mean,
it is.
the intention behind that.
Sir, even now is the same thing, right? Section 10 is only for genuine business failure, right? They take an indemnity, ki fine, we have not entered into any bad thing. We are not doing it to defraud the creditors, etc. But all this information who provides, sir? This we file 19.2 for all these only, isn't it? That's what we have been doing all our life, right?
That's
This is
what I
the
was about to say, sir, that it is a
this
good
entire list of
ideal case for the.
this is the entire list of what we were asking them in 19.2. So as it is, we have placed it here. But section 10, again, sir, Saurabh I think you will also agree that uh, if you ask them all this in the section 10 application itself, which they don't know whether it will get admitted or not, plus who all will they send notice to, right? Because you say creditors, and creditor doesn't mean only financial creditor. Do you want to give all this information to public domain for no reason? So all those things will come into picture, sir, because when you're serving, you'll have to serve the entire application on the opposite counsel. And if you had any chance of revival of the CD, that will also go away because now your competitor knows about everything inside out. So do we really need that? Uh, I mean, again, as we said, these are proposed regulations. Nothing to worry right now. When they will come, we will again do the, such seminars with ICSI and we'll learn. But today it says this, that provide everything, come with clean hands. Concept is good, practice, let's see how it turns out. Now, so again, that also doesn't hurt you. In fact, that is helpful for us. If section 10 gets admitted and I am appointed from panel, I'll be more than happy to have all this information firsthand. Now comes the real game, 12A. 12A is something which RP has to do. So far, we were doing what? 12A, read with regulation 30A. Applicant will give me form FA, will give a bank guarantee or a check or pay upfront. We take approval of 90% COC, apply to A. Correct? That was the whole process. Now what is going to happen is 12A mandates withdrawal shall be permitted only after constitution of COC, but before issuance of the invitation. Form G, right? COC to Form G. Again, 90% voting is required, 30-day timeline for A. This is what we have to take care in the regulation. What it takes care is, okay, so what select committee said, I don't know whether we really need to worry about it right now. Let's see what our regulation says. It is observed that substitution of 12A fundamentally restructures the withdrawal by fixing the permissible window and obviously ensuring that COC is central to everything. Now, imagine what kind of lobbying power this COC has over our parliament or committee or IBBI everywhere. That this COC, which has no head, there is nobody who is COC. We don't know. Their lobbying is so strong that reinforcing the central role everywhere. Okay, I'm not cribbing. I'm just discussing. Okay, align with the amended 12A. 30A is amended accordingly. What it says, provide procedural certainty, and this is the amendment. Amendment is an application for withdrawal under 12A shall be made to AA by the RP within 3 days. पहले भी 3 days था, अभी भी 3 days. Within 3 days of approval by the COC in such form and manner as shall be uh, specified, accompanied by a bank guarantee towards the estimated expenses till the date of filing of application. Fine. अभी तक ऐसे ही था. But now it says, earlier it was by the applicant, now it is resolution. Only resolution professional can come. Where the application is approved by A, the person furnishing the bank guarantee shall deposit the amount towards the actual expenses incurred for the purpose referred to in sub-regulation 1 till the date of approval by this as determined by within 3 days of such approval. So 3 days time, that bank guarantee, whatever that person had given, that applicant shall be, uh, cleared. Otherwise, bank guarantee will be invoked, right? To the bank, failing which the bank guarantee shall be invoked. Now, who is giving this bank guarantee? Applicant or CD or who?
CD.
Creditor, applicant.
Why will CD give, sir?
Applicant, sir.
No, applicant.
Applicant, sir. Applicant.
Applicant is supposed to give that, right?
Applicant, yes.
How many of us here? We are 27, 28 people. You have taken bank guarantee for 12A. I think Saurabh was mentioning just now, right? That he recently did one 12A.
Yes.
Have you taken bank guarantee or you have taken the money itself?
Sir, this was, twofold it is. So till date expenses, they have given the money. For the futuristic, they should give the bank guarantee, but
What
the
they have given?
applicant's advocate said that NCLT bench, is a common practice here. They follow is it that they give the undertaking, they don't give the bank guarantees. So this was like that only. Even though the law clearly specify word shall be accompanied by a bank guarantee.
But you filed 12A application with this
Yes, sir.
Black Rana,
Yes, sir,
right?
and it was approved also.
So this is what is happening. Bank guarantee, who gives bank guarantees, you tell me? I have not seen. I did 4, I told you. Nobody gives bank guarantee. So, but this is still there. So they are supposed to give bank guarantee. And now who is they? We don't know. The applicant is supposed to give bank guarantee. Their undertaking is as good as bank guarantee or not. We don't know. Mostly this will be with the OC only, right? 12A kind of thing happens only when there is OC. If FCs are in against, then to 12A is not happening. Most of the time it doesn't happen, right?
But in this
It was
amendment,
also.
Yes.
applicant doesn't have any role. Only COC can pass a resolution for withdrawal. Applicant need not be part of it.
Good. So you raise this thing that if applicant is not part of this process, can it still be done?
It can be the way the regulations are made.
Good. But sir, then to natural justice to khatam hi kar dega. Then it's open to everything. Because the person who has initiated, he is not satisfied. Rest 90% people are saying it's okay. Withdraw it.
So the COC is supreme.
So it is supreme. I'm not denying, but A has admitted insolvency petition on the behest of someone. How that person can be out of this game? And that is why I'm
Sir,
saying earlier applicant was a better word for this instead of resolution applicant. Yes, you were saying something.
sir, while the CD might be having a settlement with the COC members so that they reach to a 90% of conclusion that yes, we wish to withdraw. So why won't they pay or offer to the OC? And why won't OC have a right to go back to the NCLT stating that I have been left out of the process? So if
They
this
will have.
amendment comes as it is,
I'm
that
agreeing with
shall
you. They
open,
will. It
yeah,
will be challenged. Yes, it will not
yes.
pass. It will
So
not
if
pass.
there is something being offered to 90% of the people on the board, so why would this poor guy be left out of that?
I can't agree more with you because that's what I'm saying. Earlier it said applicant has to give that form FA. Now who will give form FA now? We'll see what form FA says. Huh? So form FA is this application for withdrawal of CIRP. earlier applicant was giving this, right? Whoever initiated it with 90%. So FA was coming to RP. RP takes it to COC, asks them to vote. If they vote, yes. If they don't vote, done. Correct? Now it says application of withdrawal of CIRP to the AA, application for withdrawal for admitting so and so
Yes.
person.
So
I,
this
the
shall be
RP.
by the RP after the resolution is passed, no?
So before resolution, how that person will inform you? Where is the initiation?
The discussion has to be between the COC members and the CD.
So discussion will happen through agenda.
I think formally, yes. Or otherwise, they have a
Exactly. So who
settlement
will float
outside
that
the
agenda?
COC meeting.
So who will float that agenda?
A request should come to the RP. I think procedure is
Request
missing
with
in this.
request with 33% vote, or how is it? And where is the
To
applicant?
convene a meeting, to 33% was the requisition. But if a settlement has already been agreed, so I don't know how out of the IBC process they can go and agree to something.
Absolutely, ma'am. And who will initiate? My problem is who is initiating this? There is no, it doesn't
Here,
say
here
anything.
the COC will be taking initiative the way it is made.
Yes, sir. COC cannot take initiative in silos, no? They have to put it as an agenda to the RP that proposed this. Now there is a
So
why COC is using it because applicant is supposed to who has initiated.
here
Applicant
the
ने 2 लाख रुपए जमा करा लिए, right, at the time of submission, at the time of initiation. अभी आप उसको पूछते भी नहीं.
because the regulation don't make any reference to the applicant.
Exactly my point, sir. That's what I'm saying. Earlier, in my view, 12A was much better, much clearer. Now it has gone really bad. Now it says RP so and so. See, you see, RP application for withdrawal. I hereby enclose the bank guarantee. And who is signing? Insolvency professional. Why will insolvency professional give bank guarantee?
For his own money.
And this bank guarantee comes to RP or he gives to someone?
He's
no.
only
So this should
enclosing
come
it,
from
sir.
the
He's not
applicant.
giving it.
I agree. So this comes to RP, correct?
Yeah, yeah.
It will come to RP.
Yes, of course. He won't give it from his pocket, no?
You got
He
my
has
point,
to be
right?
paid out of those expenses.
Exactly my point, ma'am. So how that bank guarantee has been received? Earlier, bank guarantee was coming along with Form FA to us, correct? Was supposed to,
Yes.
isn't it?
Yeah, that
Yeah.
was coming from the applicant. That is why he was
From
giving
the
the
applicant in along with Form FA, isn't it?
Yes.
Now, by changing this word that you put RP as making Form FA, this has gone, I mean, totally bizarre. Either use FC or FD, something where this person can propose to you. Right now, it's totally open. So, in my view, this form is useless uh, because see, one page application can't go to NCLT, isn't it? Now, don't expect
It
that
has
this
to be in
Form
a
FA,
proper IA format.
exactly. So, this Form FA will not change everything. This Form FA was only to intimate that fine, now the 3-day has started. Now, when will the 3 days started, you tell me, for RP to initiate this 12-way process?
After the resolution is passed by 90% of members.
How so not from the day resolution is
The settlement is received.
proposed.
No, not from
Not
that.
from the resolution is proposed.
No, sir. How? They will take their own time. 90% of
Earlier,
people have to.
earlier it was not there. Earlier it was saying from Form FA, immediately do the COC and do it. Correct?
Right.
Now
who
where
will
is that?
initiate this process. That is the point. Whether the
Right
COC
now
will
I don't know
initiate or applicant will
exactly.
initiate.
So I don't know when to initiate or when will you count the initiation. So Form FA, again, my views are either they will add a Form FAA or something, right? Uh, because otherwise initiation date I'm not aware. And applicant is done away with. He is nowhere in the picture, which again is a might be fatal to lot of open to litigation, I should say. That will also happen. But this is the state today. Form FA will come. You will file Form FA within 3 days, take 90% approval. But it can only happen Form G and COC
If
form.
the COC wants to protect the CD, then this form will be of any use.
सर COC में कौन डिसाइड करेगा? Who will initiate? वो भी नहीं है अभी. That's the problem. And that is why
इसका अकाउंट रेगुलर है, वो करेगा, बोले ठीक है
that is
मेरा
why
अकाउंट
applicant
रेगुलर
was
है
a better word, sir.
Yeah.
That is why applicant was a much better word to take care of this issue.
But
I think they want to take our applicant out of this picture. That is the intention, it looks.
Earlier, these promoters were discussing only with the applicant, settling with him used to halt the process. But
Correct.
now they are wanting all the creditors' interest to be taken care of by the promoter.
मैम एक मिनट,
This
वो
has
तो
been
पहले भी होता था.
formalized and
वो
this
पहले
will
भी
come
होता था.
through the
मैम एक सेकेंड.
agenda.
मैम एप्लीकेंट के बाद आने के बाद COC के पास तो फिर भी जाते थे. सिर्फ उस केस में नहीं जाते थे, COC नहीं बनी है.
जब COC फॉर्म नहीं हुई है तो
Exactly.
वो खत्म कर दिया इन्होंने.
Exactly.
एप्लीकेंट्स
जब
को
वो खत्म हो
वो
गई,
देयर
जब
वाज
वो
अ
खत्म,
माल प्रैक्टिस आल्सो ना,
तो फिर
जस्ट टू
बाकी
गेट इट
चीजों,
एडमिटेड एंड देन सेटल.
हमें जी बाकी चीजों को बदलने की क्या जरूरत है?
The format needs correction. I understand. I agree.
जब आपने टाइम फिक्स कर दिया, फिर तो बाकी सब चीजें तो ऑटोमेटिकली सही चल रही थी, कोई प्रॉब्लम नहीं थी.
Right.
So that's what I normally say, that don't change something which is not broken. If that was doing fine, why to change it unnecessarily? But this is what it is. Now, manner of collating is a fourth point. Otherwise, we'll not be able to finish liquidation. I'll rush through a little bit. It says collating claims. Now, not only collate, but you are supposed to verify, reject, admit, whatever you want to do. So this is the proposed regulation. IRP or the RP, as the case may be, after verification, either admit or reject in whole or part and communicate the decision within 7 days. So this has to be done by the RP now, and inform them also that fine, we have admitted or rejected. Section 19 was simple, as I said, personnel to person only they have changed. So even if those were not employees and only related or associated with the seat, they will also be answerable to. Assistant and cooperation by the personnel of the CD will be substituted by persons. That's not much of a difference otherwise. So more of a lawyer game than RP game. Okay. Deemed appointment of RP we have learned. Now you don't need to file an IA specially. Just inform everybody. Everybody means board, CD and IR. That was in section 22. I don't think there's any need to work on that. Yeah. What happens if replacement is there? If you're confirming the same IRP to RP, there is no problem, no need to file IA. But what happens if you're replacing? Then obviously we have to file an IA, right? Then 22(7) will come into picture.
You also have to recommend.
Then things will remain same. Okay. Manner of condition of transfer of asset, that is 28A, right? The new introduced section, this one. So how do you transfer that asset? It says whenever everybody agrees who has taken a possession, good. I think this we have discussed. Here they only said RP of that particular CD who was corporate guarantor or PG shall coordinate with this RP to transfer this asset. 28A, transfer of assets of guarantor taken into possession. Detail, first you place detail, estimate realizable value, consent of the creditor or COC approval. Wherever they approve, how you do it? Ensure proposed transfer is disclosed in IM, tell the information, how much it will cost, how it will be treated in the resolution plan. Fine. And someone was asking me earlier, the terms of the resolution plan shall provide for treatment of proceedings arising from such transfers. So regulation 3C talks about that. So this is enabling. Second is facilitation. Now, who will facilitate? RP of that particular is duty bound now to facilitate this transfer. Right? Again, this is any observation here, or I can move because it only says if you have your thing, you want to give it together, give it up, no problem. Right? So it's a good enabling provision. How it plays out on the ground, it is to be seen later. Then manner of payment of financial creditor who did not vote. This is about your dissenting financial creditor. Only word you need to remember is not less than the lower of liquidation value or the plan value. And so obviously no change is required because this is only danda hi to manna hai. So it's like that. Condition and manner of constitution of a committee to supervise the plan. No additional regulation is being recommended because that is already taken care of in the implementation. Last was form, manner, and condition for the AA to first approve the implementation and then the manner of distribution, right? We said two-part approval. So how they will do is there's a new regulation, regulation 39, which says, so 39 was about regulation approval of resolution plan. Here 3C is inserted. It says, for the proviso, the resolution professional shall file in such a form as may be notified. So that form is notified. And one more thing they have changed is, if you want to decide that this may be done in two parts, then you should file your plan approval not 15 days but 30 days in advance. So within 150 days, ideally, you should be filing it. So instead of 30 days, instead of 15 days, you should file before 30 days. Practically, it's not going to happen. So let's see what comes up. RP shall endeavor to submit. So this I have mentioned. 11 is manner and condition of COC to apply for restoring. Right. So this is again new thing. How will the COC decide to restore? Now, COC has to explicitly restrict such restoration to a single instance that you need to remember can be restored by for 120 days by 66%. Now, what is that form? So this is the new regulation 40E, restoration of CIRP. Under this regulation, we will be filing under for this purpose, that purpose. Application under section 2 shall be accompanied by resolution of COC, brief note for setting reasons, and the proposed timeline how they are going to do it. That's all. Condition of dissolution. Resolution, if they say before taking the decision, without going into liquidation, straight away, like dissolution can happen. That's all it says. 40D allows that decision for liquidation. Straight away also we can go for this, right? Again, as RP will not have quarrel on that, it's a good provision. A release of guarantee. Again, background we discussed in the morning today, why it should be done and not done. What it says is Amendment Act through explanation unambiguously settles the legal position. Approval of a resolution plan does not release guarantors or promoters or the co-obligators. So that cannot be wiped off through the resolution plan. But what happens if COC decides to do it 90% approval, 66% approval? Any idea? If they decide to let it go,
Can be done outside the resolution plan.
okay, you're saying it should be outside the resolution plan, not in the resolution plan, right? Okay, No, sir, outside the resolution plan, then it won't be binding on other people, right? So I agree with you, sir. If they want to release that guarantee, they may choose not to follow it up, but it can't be wiped off through the resolution. And this is that amendment, very simple regulation. A resolution plan shall not affect a claim or any proceedings in respect of a person who was promoter or in management or control of the CD or any other person referred as explanation 1 to 6. That's all. So, okay, one more change they have made is now forms will not come through regulation, they'll come through circulars. So as an RP, so right now what we were doing, we were not worried about circulars so much. We were only worried about regulations. Whenever you need a form, see the regulation, latest regulation, publish it. Form A, Form A, B, B, C, CA. Any change now, all these forms will be changed through circulars and not through regulations. So no need of taking public comments, etc. They can do on their own. Again, as an RP, I don't think we have much say in that. So we accept it. And this amendment only says A should be read as so and so such form, B should be read as such form, C should be read as such form. So nothing to discuss here for us. That's all. That's all in the CIRP regulations changes. Anyone has anything on CIRP, or I can move to liquidation? No? Okay, fair enough. So we'll go to, we'll cover our liquidation regulations also. What are the main changes in liquidation? COC will continue, SCC gone away, RP cannot continue as liquidator, and there is no going concern concept. And anyone? Any other change? Major change?
Moratorium will maintain.
Moratorium will apply, and
The timelines 180 days plus.
instead of 1 year, 180 days, extend by 90 days, correct? And sir, any other? You if you can remember. That's all. Okay. मोटा मोटा तो याद है ही ना सर ठीक है एक क्लास में इतना सीख लिया बहुत है okay let's go one by one here luckily in this proposals they have given a chart kind of thing which is easy to read so all these amendments they are towards one thing which is operationalize the legislative shift from SCC to COC. Time bound process 180 days. Liquidator fees is reduced. Now it is no more based on the distribution. Earlier we had 50% on distribution and let's say X on when you recover and X by 2 when you distribute. Now it is simpler 5, 4, 3, 2, 1 and nothing on distribution. Or if you're taking monthly, then there is no problem with that. Verified claims, carrying forward of the verifying claims is there. COC oversight will be there. Replacement of liquidator. Earlier, this option was not there. People were going through 60/5 only. Now, there is a formal mechanism. And again, in liquidation, you can do 28A, which is transfer of assets of the CD. Again, avoidance, fraudulent, wrongful, harmonization is there. So key changes, SCC regime is replaced by a statutory COC. And that is why they inserted this definition. No problem, good with us. Liquidation cost, now these are no longer part of the liquidation framework. Why? Because COC has come now. Let them take a call. पहले क्या होता था? You had to ask the financial creditor to contribute to it, right? And other people you will not ask to contribute. Now, since COC is there, then they are responsible. Same way, contribution to liquidation estate, if somebody is doing how to meet the liquidation cost, regulation 39B, right? This provided FC to contribute towards excess. Now FC SCC wala concept khatam ho gaya. So now COC will provide for the same. Another modification, only if amount realizable to the creditor pursuant to the scheme is above the liquidation. Okay. So going concern concept is over. Agreed. But in Companies Act, there is still a section called Section 230, right? Compromise or arrangement. That has not been done away. That is still there. You can do it, but it should not be below the liquidation value. So compromise is still not done away with. It still says in liquidation, sale of an asset via an auction bidding process is conducted in this. Accordingly, reforms are proposed. So in my view, they don't say crush 230. It can be done. Okay. Again, liquidator fees. They say we are rationalizing is due to the lower burden on the liquidator. Since liquidator doesn't have to verify the claims or admit the claims, the fees should go down by so and so. Again, if you have monthly fees, then there is no problem. But if you work on that, table, then this might be little problematic. Then reporting by liquidator. Earlier, we were filing preliminary report, asset memorandum report, sale report, quarterly report, right? Now they say no need to file that. We are doing away with this multiple filings. Minutes of the COC asset memorandum shall be report in the pro review. They said no, now no need of that because COC is there now on your head. No need to go to NCLT for everything. So you tell them, they will take care. Again, new insertion regulation is amended to provide that appointment of professionals shall be with the COC approval. In liquidation, liquidator had that right. Only the fees approval was there. Now they say no, approval is also COC, similar to your CIRP, following in line with the approach followed by CIRP. New regulation reconstituted the COC based on the updated claim. Secured creditor who has not relinquished will not form part of it. Now, operational section 21 and 52, COC with CIRP experience. Okay, now this is interesting. Huh? It says COC with CIRP experience brings commercial oversight and continuity to the liquidation process, improving efficiency and accountability. Now, how many people agree with this? This is something because, this is a direct impact on us. How many people agree on this? That COC, when they are continuing, they bring commercial oversight and continuity and institutional memory. उन्हें पता है क्या हुआ था CIRP में, तो they will do in liquidation also.
Sir, practically all of us have experiences. I'm sure all of us. They are not the similar people who allowed the loan in 2011 or 12. They were not the similar people when the loan went into default. The problems started, financial issues started with the company. They were not the people who were there 3 years ago. And now they are not the people who are taking decisions only. So, 5 set of people we are talking about, where is the memory lying? I don't understand. And one person handling 280 accounts. And for
So
3 years, he's there.
memory is they say you learnt in CIRP what was happening, so you will continue in liquidation. Now, if I take this
As a
line
logic,
of
or why not
thinking,
RP is continuing?
then
Tell
why
me.
RP is not continuing? Where is his memory going out? If we use this line of reasoning for COC, why RP cannot continue then? Then RP also has a fair memory, right?
In
By
fact,
the same,
RPs are under so many obligations to keep record, have a justification of which decisions were taken, why not taken. Bankers do not find their own files only because it was the earlier person. We don't have access to those records right now. It will take 2 months maybe to give you one answer. So
so somehow
theoretically, we wish the very
logic
best.
is, if this logic is taken, then it should have been RP only continuing. But unluckily, somewhere you give one logic at the same time, then you ये ऐसे जो अपनी बात को ठीक करने के लिए जो भी बोल दो. So here there is institutional memory. For RP there is no institutional memory, but
RP can be compromised, that's why.
COC
Easily
can't be,
placed.
right? Okay. Okay, so we are all RPs. There is no COC member here, तो हम कुछ भी बोल लेते हैं उनको. But uh, we know that, sir. See, in my view, I have no argument in replacing RP with another liquidator. No problem. But then don't give logics like this. My problem is this. When you give these logics, who is asking you for logic? CIRP experience brings commercial oversight, and continuity. If you'll give me same logic and just one step up, you have said RP will not continue. So that creates unpleasant thing, but that it is, right? Okay, substitution, right? COC, we have agreed. Ensure regular transparency COC, enable informed oversight. Okay. So you remember I told you that a liquidator now doesn't have to give the liquidation estate, what was the estimate, etc. They say there is no meaning of cost overrun, etc. No need, because now every month you are providing it to COC any which ways. So this is a good move. This is positive for everyone, no problem. Again, align, what was that? Again, nothing. Okay. So this was about remuneration of professionals, etc., etc. Needs to be done. All this is aligned as of COC. Now they say RP does not have to work independently. Neither they have to tell SCC every quarter. Now do your COC as you are doing CIRP. Run the liquidation like a CIRP only, which is easy for us to remember. We don't need to get into any of these things. They say every month, tell your COC what you are doing, take their approval, finish it off. Very easy. So life has become easier for liquidator that way. Okay. Again, facilitation of transfer of assets, right? How we do it in CIRP, we just learned. Same way, even if the company has gone into liquidation, we can use the same process and transfer it to the CIRP of the main city. So that again, enabling provisions for that. 8B says replacement of liquidator. COC by way, again, 60%, 66%. If they want, they can replace. Which was there earlier. Earlier also they were going, SCC was going, but SCC में 66% लाना बड़ा मुश्किल काम था. Now COC में 66% लाना is easier that way. Okay. Replacement we have learned. Okay. Disclaimer of onerous property. Onerous property is which you don't want to continue with, right? Time aligned with the revised timeline proposed in 180 days. So now they say within 90 days you have to decide. Earlier it was 180 days because time was 1 year. Now since time has reduced to half, this also has been reduced to 90 days. Public announcement. Public announcement during the liquidation call only upon stakeholders who have not submitted the claims rather than all. So when you publish your newspaper, don't say everybody will file. Say only people who have not filed or people may revise their claim, right? They can submit. Otherwise, You don't take it from everybody else. Fine. Submission and updation. Claims submitted during CIRP are carried forward. Fresh submission applies only to newly submitted claims or the updated portion of the existing claim. Fine. And I think Saurabh was only asking that if somebody wants to add interest, it says a creditor shall update its claim as and when it is satisfied from any source. So this is actually the updation, not going upward, but downward. Fine. With this, what else? Relinquishment. So relinquishment has traveled many a times to Supreme Court also. Some bankers also have taken. They said we could not do it in so much days. We are informing now whether it comes automatically. So 30 days to 14 days automatic relinquishment is there if they do not inform. Fine. And within 90 days, they have to execute. If they are not able to do it 90 days, change it. Rejection of claims and communication. Yes. So if you are rejecting a claim, answer within 7 days. If you are admitting, then also you can inform in 7 days. Same as IRP, same as liquidator. RP, IRP, same. Okay. Liquidation timeline. Now timelines, because 1 year, 180 days. So they have aligned little bit. That timeline we'll see. What else? Sale of assets. Okay. Now, sale of assets, earlier this was not really clear. Now, sale of asset cannot be done to ineligible people who are ineligible under 29A. So, if 29A, they could not be resolution applicant, that means they cannot take the assets also. So, that continues during the liquidation. Mode of sale. Now, mode of sale says related parties. Again, that part is like in resolution, it's not possible. Here also, RP related, anybody who's related to RP or valuer or liquidator, they shall not acquire any assets. The person who has gone into liquidation or bankruptcy, they should not acquire. So integrity of the process is, shall be maintained. That's what it is. This is one topic I think which I believe Armiji used to take a lot. Assignment of NRRA. Here they are making slight change. They are saying whether crystallized or not, this can be assigned. So crystallization is no more a precondition for assignment or transfer. I think a fair, a decent amendment, because earlier they used to say we don't know how much we are. Suppose you have filed a PUFE application. You have asked for 50 crores. Now whether you will get 50, 49, 7, 25, how much you will get, you are not aware. And once you are aware, then you start selling NRRA. Then how much they will provide, it used to be a lot of time. Now they say whether crystallize, not crystallize, you can still sell it. That is it. Any observation on this, or it's a good move?
It's a clarification, so it will help many RPs to go further, because sometimes the COC was not in a mood to carry out such auctions, etc. So now we have the enforcement of law behind what we are doing. But otherwise, we were doing it a lot. Earlier also, some avoidance transactions application stage itself, they were being sold just to close the entire proceeding.
So practically we were doing, now it is in regulation.
Yes.
That's it. Yes, absolutely. Dissolution. Now dissolution is 54. Operationalize section 54A1 and 1B. What it says, if you are even after dissolution, your PUFE application can be continued by the whoever person you are assigning it to. It can be COC member, can be anybody else also. Dissolution, early dissolution. Since SEC is not there, COC is there, and it says if you don't want to continue, do the early dissolution also. Direct dissolution is also possible. Early dissolution is also possible. Like one of our member, he asked an interesting question. Let's say a CIRP is going on and COC decides in the second COC meeting itself that we will go for liquidation. Fine. You got the question. In second COC only, you decide there is no meaning of CIRP, will go for liquidation. In that case, will the RP be replaced or not?
Will have to be replaced, sir.
उसने तो अभी कुछ किया ही नहीं है.
तो करने से नहीं है ना सर, लिक्विडेशन में जा रहे हैं अगर.
He was saying, no, RPs are doing hanky-panky stuff. That is why the person should not continue. So now what is his fault?
It's a law, sir. We are not giving any reasons of replacement.
So I don't know if that person is listening, but that's the answer, sir. Even if it is second COC, they decide to liquidate, same RP will not continue.
Have to follow the procedure as it is written for.
Correct. Okay. So dissolution application format, they are providing it. I don't know whether it was required or not. Okay, so in format, they have changed slight changes. Earlier, if the liquidation cost exceed the estimation liquidation cost, reasons had to be provided, etc. Now, no more of that thing is required. Fine. Again, circulars, forms can be notified not through regulations, but through circulars. What else? Okay. Reduction in price. This might be important for us. Earlier, we could reduce it by 25%. Right? Now, even in the first COC, you can only reduce it by, in the next auction, you can reduce only by 10%. And they say because Bankanet is so successful, there is no need to reduce by 25%, reduce only by 10%.
And the process shall finish within 180 days.
Exactly. So these are two different things to talk about. On one side, you're saying reduce the time, but they're saying reduce less, thoda, thoda, thoda. If market is good, then obviously you'll have more participation. People will come automatically. And reserve price doesn't mean it will go on reserve price. It can go, it's a bidding process, right? People can.
What if the COC resolves to reduce? They cannot.
Ma'am, regulation says no. Clause for Schedule 1, reduction of reserve price shall be with the COC discretion to reduce up to 10%. So no हो सकता है, 11 नहीं हो सकता मैम.
Lot many extension applications shall be filed in liquidation also now. Already they are being filed when the
One
assets are
time
not getting
only you
sold.
can file. One time only you can.
Yeah, we have seen that.
So law says one time you can file this.
Yes.
And it says consultation with SCC is replaced with approval. Doesn't really matter because COC is there with us. Model timelines have been changed accordingly. So 1 year reduce into this. So that's the change which has come. Other than this, I think is more of an explanation only. Unremitted TDS, TCS. I don't want to take this up because we believe there will be a lot of changes here because many people have given their suggestion. So this regulation might be twigged. So let's not burden ourselves with this for the time being. And yeah, these are the notifications which will come. You have already seen. Now there is only one table. First 1 crore, 5%. Up next, so up to 10, it is 5, 4, 2.5. So 3.25, 1.8, all that is done away. Now it's 5, 4, 2.5, 1.25, 0.25. And so first 6 months, next 6 months, and thereafter. So this has to come. Nobody will be able to challenge
But
this, so it's
but
going.
if the liquidation period is 180 days only, it is first 6 months only.
Yes.
So next 6 months doesn't come into picture.
सर एक्सटेंशन ले लिया आपने फिर
तो भी 90 days का ही होगा ना सर।
तो इसमें हो गया ना सर.
हाँ आई मीन हो गया बट देर आफ्टर तो हुआ ही नहीं और ये भी 6 months नहीं 3 months ही हुआ ना सर टेक्निकली.
करेक्ट करेक्ट. सो वो लिखने के लिए है सर, उन्हें भी पता है एक्सक्लूजन ये वो हम कर लेंगे. ठीक है. सो लिख दिया है आपके लिए. Okay. So with this, COC will continue. No argument on that. Fees liquidation. So now I think it's better to have a monthly fees only as liquidator. Now no need of getting into the what you call waterfall. Because see, earlier waterfall would have been, for some people it was really helpful. Now it's not, because if there was anything left, they would have reset the CRB. Now, since the CRP has not been resetted, it means there is actually nothing left. So when nothing left, then what will you get out of percentage of zero? So that is why try go for your
But
simple.
sir, for monthly fees also, now there should have been a minimum prescribed
Yes,
here.
yes, that is not mentioned. That should have been mentioned. Like CIRP, if monthly can be done, yes. But since there is a schedule, that table is there, I don't think they can give both the options. They'll say either
But
this or that.
I don't know why there are certain professionals who just spoil the market. They quote such low fees. How they manage to run the business thereafter.
काम चाहिए मैम, सबको काम चाहिए इसमें.
पर
Okay.
कॉस्ट भी नहीं निकलता है सर 20,000 जैसा कोट करते हैं पर मंथ. I've seen those
As
quotations with
liquidator,
SBI.
as liquidator.
Yes. Yes, I've heard that from SBI.
Okay. Maybe. Try not to take at 20,000 people. I mean, whoever is here, at least, let's maintain some dignity of the profession. Okay. So facilitation of transfer of assets, again, enabling provision, we have already learned. If that asset needs to be transferred, COC can approve to transfer. Replacement, again, 66%. Whenever they want, they can replace. And no, my problem is one more. Before we close, we are almost there. In this regulation, let's say somebody has worked for 5 months and the asset is about to be realized, but has not been realized. Now, will that person get some money for that 5 months or not? Or only at the end, it's like the winning shot only counts.
Only at the realization, I think.
Sorry, sir, I missed you.
I think only on the realization it is.
So only the winning shot counts, huh? You're saying?
Yes, yes.
And is that fair?
Can't comment.
No, I'll tell you why. Because if that is the case, then they will let the liquidator work for 5 months and replace every liquidator on fifth month, fourth month or fifth month. The moment you feel it's about to get in the kitty, replace. So that way you don't have to pay. And then you can hire someone for 20,000 per month.
True.
That's possible, right?
True.
So I think it was not settled earlier, and now also it's not mentioned. They say let market forces determine it. But in my view, this is a lacuna, sir. When this
Actually,
person can go, or if
whenever the NCLT pronounced the order, they don't mention anything about fees. They just say that it is as per IBBI regulations.
absolutely, sir. No, so what we will do? Let's say you have worked for 9 months, 10 months, and at the time, right at the end, they ask you to go.
It's a nightmare, sir, for the liquidator.
Okay, so we agree on that. and then final reporting, etc., etc. You have to file. All these are whatever we have discussed so far. Replacement of liquidator, quarter period, which was there. Now this all will be done away with. Now it's only if the court says monthly report, how we were doing to COC. So CIRP has become COC. That's all you need to remember. And the model timelines, I'll just open it. This is last session of my day. Okay. So commencement appointment, you may ignore this for the time being. We are only concerned about this. Public announcement, T+3, T+5. Submission of claims, same, 14 days, 14 days. Verification of claims, T+21, T+21. Now, constitution of COC within 2 days. Here, there is no reconstitution because same COC is continuing. First COC within 7 days. Because reconstitution नहीं है तो same COC के साथ you can do it. Earlier it was lot more, right? 2 months के अंदर. Appointment of 2 valuers, 47th day we had to do here within 7 days. And obviously no form G, etc. is proposed here. But this has also become T+20. So with this, I guess I have covered the amendment and the regulations. If nothing else, then we'll leave you for the lunch. Saurabh anything? You've been...
Sir, I mean, amendments are definitely, there are many amendments, and let's see when it comes into notification. I have one question. So till the time these are not notified, let's say if I'm handling a liquidation case, the SCC should continue.
Everything continues same as it is. Whatever was happening, you will continue.
Okay. So another thing, not on amendments, but a quick help or guidance is required. So let's say 19.2, which is for the corporation, a CD don't cooperate or don't provide the details. And application is filed, NCLT says that within 7 days you have to give all these things. Then also it is not given. Then a contempt application is also filed. And that also, I mean, till date, nobody provides you. So what RP or liquidator should pray, I mean, should include in the prayer or should, I mean, argue in front of NCLT? Should be, it should be kind of warrant or what it should be, I mean, ask about.
So that contempt is not giving any result so far. No problem. I know what your problem. I think every one of us are facing it. NCLTs somehow unluckily they don't have that teeth to catch them. They are not even issuing warrants as such. So I have not seen any one issuing. Being a tribunal, they haven't issued any warrants also. Uh, uh, I don't have any answer on this platform for you, sir.
Okay, no worries. I can understand.
Yes.
Thank you. Thank you.
That's my take. If somebody has some solution, please share. Otherwise, no. Okay. Okay. So with this, thanks for being here. Have you a good lunch, and after that, Anil Kohli ji will take you through all other CIRP and those will be really interesting because we haven't done them yet. So अभी तो हमें CIRP और liquidation के ही regulation को ठीक करने में time लगेगा. So in my view, CIRP will not come in the first line. It will only come in the second line. But let's see how it turns out. Yeah. And once they're finalized, we'll hopefully meet again and take you through this. So with this, I'm Devvart Rana. I'm advocate and practicing in Delhi. If we can work together, please do feel free to contact and have a good day. Anjali ji, we can close it, please.
Thank you, Rana ji. Thank you very much. Thank you.
Thank you very much, sir.
Thank you,
The
sir.
session was very wonderful. Sir, please share the material also.
Okay, this was amendment only. So if you want, I can say same thing.
Okay, sir. Now there is lunch break till 3 p.m. Second session will be taken by Anil Kohli sir at 3.
Okay, ma'am. Thank you. Thank you very much.
Thank you, sir. Thank you, ma'am.
Thank you.
राणा जी, अगर आप शेयर कर दोगे ना, तो जो आपने हाईलाइट किया हुआ है जो अमेंडमेंट्स में, तो इट विल हेल्प ऑल ऑफ अस सर टू बेटर अंडरस्टैंड विद ऑल योर जो आपने टीचिंग दी है आज हमें, तो वो बड़ा अच्छा रहेगा हमारे लिए।
Sir, I will ask him. Actually, he had left it.
थैंक यू मैम, थैंक यू।
गुड आफ्टरनून। हाँ यही है कि कहीं बाहर है? एक व्हाट्सएप पे भेज दिए हैं, देखिए देख लीजिए। 7:30 है।
Sir, shall we start?
हाँ हाँ
Yes, definitely. Prasad, you are there? Prasad? Prasad, please load the this thing, our
आप तो है ही ना।
our presentation. Prasad,
होगा क्या? ऐसे कुछ होगा नहीं।
Prasad, load the presentation. ना, I'm in the group. आपने अंजलि जी, आपने शायद उनको ज्वाइन नहीं किया। हमारे मिस्टर प्रसाद इज इन वेटिंग रूम। He has to load the
लेकिन इसका तो सरकारी ऑफिस में टेंडर है।
हम
Let me check, sir.
वो अभी उसमें है वेटिंग रूम में।
जो है वो नोएडा से करेंगे। वो करेगा तो ऐसे तो स्केल अप फिल्टरिंग हो जाता है। उसका चक्कर
या टी मार्क के नाम से या मे बी। प्रसाद, यू आर देयर?
Yes, sir, he has joined.
ओके, तो मैडम ये डेल को आप म्यूट कर दीजिए प्लीज।
हाँ वही तो लिखे हैं।
अंजलि मैडम,
करा देगा। कितना पैसा? कितना पैसा?
अंजलि मैडम, कैन यू प्लीज म्यूट द पार्टिसिपेंट्स?
नहीं, उसको हमें उसको
Sure,
देना
sir, give me a second.
प्लीज।
ठीक है, ठीक, कुछ के बताते हैं। ठीक।
They're all on mute.
Great. So let's start, madam.
Okay. Good afternoon, everyone. Now the second session will be taken by Anil Kohli, sir, on topic amendments other than CIRP and liquidation process. Let me briefly introduce Anil, sir. Sir is chartered accountant, advocate, IP, and certified mediator. He is highly competent professional, dedicated in resolving distressed assets for last 22 years. In the realm of IBC, he has showcased his experience in managing some of prominent entities like Moser Bear, GVK Gotmi Power, Winsome Yans, Dehradun Highways Projects, Max Tech Oils and Gas Services. He has successfully resolved over 25 cases through implementation of resolution plans or going concern sales. He has very impressive track records of over 2 decades in assisting financial institutions and banks under SARFAESI Act as well as IBC. He is also a designated partner at IP ARCK Resolution Professionals LLP. He has been actively engaged in IBC. Under his leadership, IP has managed a diverse portfolio of over 120 insolvency cases. Now I request sir to kindly start the session, please.
Thank you very much. So thank you IPA of CS Institute for giving me this opportunity. So good afternoon, friends. So we all are colleagues in this profession. So I will start by saying that yes, these amendments were the most awaited, event to happen in IBC. We had gathered a lot of issues which needed rectification. So how come it's getting changed? The picture is getting, I think, okay. I'll just so fine. I'll keep it on off. So basically, after a lot of 10 years of IBC approximately, so we have seen that some judgments had came like Rainbow and all. So there were certain issues which needed to be addressed, and also like pre-pack was brought in to fasten the processes. However, it could not work that well. So now they have brought in a new process called CIIRP, Creditor Initiated Insolvency Resolution Process. So then there were certain requirements in PG matters, and then in also in group insolvency and this cross-border insolvency. So there was some requirement of some provisions of law. So all this has been addressed by way of these amendments. So we will take up what all has been done till now. So though we are waiting for the notification, Parliament has approved. Also, the President has given assent to the amendments. So notification, since the government would like to bring in the regulations along with the code so that to implement the code smoothly. So maybe since 5th May was the last date for receipt of suggestions on the discussion papers. So we'll take up the discussion papers also to understand more that what all is the thought process. So then maybe in another 15-20 days, or maybe around on the 10th anniversary of our code, these notifications. Before that, I am very much hopeful that there may be the notification. So let us start with CIRP, Creditor Initiated Resolution Process. Prasad, can you move the slide? So we will discuss on the no. You can keep it there. I'll just take up what all topics we are going to discuss. So we'll discuss about important amendments and CIIRP, then amendments with respect to PGs, then group insolvency, cross-border, and then IP-related amendments and other miscellaneous amendments of IU and some other things have been done. So then discussion papers. We'll take up the discussion papers simultaneously along with each and every process. So Prasad, yes. So introduction. So important amendments are, first was introduction of CIRP is the most important concept which has been brought in. Then Rainbow, all this Devvrat ji have already taken up, maybe Rainbow judgment and restarting CIRP for the second time. Then stringent timelines for admission of CIRP, transfer of PGCG, so personal guarantors assets under CIRP. So order of approval of resolution plan within 30 days or liquidation within 30 days. Then RP cannot become the liquidator is another thing which is of interest to all of us. Then direct dissolution without liquidation. Then order of dissolution within 30 days. So let's go ahead. So CIIRP, Creditor Initiated Insolvency Resolution Process. So the issues which were being faced and have been tried to be addressed here are basically there is a delay because of NCLT's NCLT's admission process. So there was certain delays which lead to value erosion. So if the admission takes a time, and there was a ruling of Supreme Court, as you all are aware, that 14 days is directly and not mandatory. So due to which NCLTs and also Vidarbha judgment. So because of his NCLT is looking into various issues in the admission process itself. So CIRP has been brought in to address this issue. then tribunals already are overburdened, and due to infrastructure, lack of infrastructure and all, yes, we cannot blame only the tribunals. So there are certain other points also. So then excessive litigations because of the promoter indulging in opposing the admission processes. So there was excessive litigation which which further means more cost and all. Then there was a delay before moratorium was imposed, so there was a possibility of depletion of assets and also erosion of asset value. Then long timelines, lower recovery. So longer the timelines, lower the recovery. That is definitely the name of the things. So because plant and machinery, and also there was the possibility of keeping the CD as a going concern, which is the prime motive of the CRP process. Basically, the IBC, the major benefit is revival of the corporate debtor. Otherwise, for the assets, there was SARFAESI earlier also. So the bankers could have enforced their security interest and under SARFAESI Act and encashed the value of the assets. But very unique USP, I should say, of our process of IBC is that there is a chances to keep the corporate sector alive and revive it properly, and for which definitely results in safeguarding the employments and safeguarding the economy also. Basically the production capacities are kept intact, which definitely works out to help the economy. So that itself was getting minimalized. So the possibility of revival of the CD as a going concern. So CIRP is a initiative wherein the creditors, so it will be notified which all creditors will be entitled to initiate this process. However, the definitely scheduled banks will be there. So with this process, the bankers themselves, the financial creditors themselves can appoint the resolution professional. So we will see how the process goes. So there is no requirement of NCLT's order for appointment of RP, and the RP can proceed further and conduct the process like CIRP, but with the difference definitely that debtor will remain in possession. However, under the monitoring of the resolution professional. So we'll see further how what all is going to happen in this. So basically, IBC had prescribed 330 days timelines for the resolution, but however, we have seen that some of the cases have continued for even for 8 9 years. So and then 30,000 matters are pending before NCLT. So CIRP is creditor driven and larger out of court insolvency process. And like I have said, that the eligible financial creditors will be able to initiate the process without waiting for admission by NCLT. So the amendment shifts the insolvency resolution from courtrooms to boardrooms, leading to more commercial negotiation, less judicial interference, faster restructuring, reduced procedural litigation. So the objective is speedy resolution, value maximization, minimal business disruption, and better creditor recovery. Yeah. So how it is different is that it starts before formal admission by NCLT, like I have said. So once the creditor gives the notice to the borrower and the representation is received, and 51% of the creditors are okay to appoint a RP. So the RP may be straight away appointed, and on appointment, the RP is to again then follow the same things like in the process at least. He has to publish the Form A and all those things, and all other things remain like in CRP, except that he will not take over the management of affairs of the business. He will sit in the boardroom. So no custody of assets etc is there. Certain things are not applicable in CIRP, so which we'll see further. Then, code driven beginning has been shifted to creditor driven beginning. Then immediate judicial involvement, say it has shifted to limited judicial involvement initially, because if there is an issue in the process and it cannot be run as it has been proposed, so there is a possibility to go to regular CRP by invoking the jurisdiction of NCLT, and even the promoters will have the right to go to NCLT if they are aggrieved by the appointment of the RP. So there were more litigations there, less litigations here. Then slower admission, say it goes to faster initiation. This will have, basically, in my understanding, the this CIRP process will be more of we can say persuasive effect, like the creditors may be able to put the borrowers immediately on defensive by by seeing that their company is already going into IBC, and immediately they have to act upon it. So it will definitely lead to very early resolution, extremely early, maybe the borrowers, because now they are aware that IBC definitely is working very effectively, and their companies have been shifted to newer managements in most of the cases. So there is a fear factor amongst these promoters, and it is being now, IBC is taken very seriously, and the promoters are wary of this process, and they definitely would immediately try to act upon it. So as soon as they see that something like this is coming in, so definitely they take it serious. So primarily it was in court CRP, now it is hybrid, we can say, out of court, but somewhere the court interference is again here too. Aage. Yes, Prasad. Yeah. So then introduction in the code. So section 58B deals with the initiation. It says that only specified financial creditors can initiate, and operational creditors are not the primary drivers of CIRP. So because it will be very difficult to handle them, so therefore this has been kept. So against which corporate debtors? 58A deals with that. It says the corporate debtor which assets or income or both below such levels, so which may be notified, will come to that. Then corporate debtor with such assets or class of such amount of debt or such other category of debtors as may be notified by the central government. So both the things are to be notified by the central government, the financial creditors as well the corporate debtors on which it will be applicable. That against which it cannot be initiated, which also is dealt in 58A, for which an insolvency resolution or liquidation proceeding has been commenced and still undergoing, and that has undergone a CIRP pre-package or completed a CRP during a period of 3 years preceding CIRP, so that there shall not be multiple litigations. So this safeguard has been kept, that so there is a safeguard about of at least 3 years. So for reinitiation of the processes. Yeah. Summary is basically, so eligible financial creditor, if he detects a default which has been done by the CD, so he will seek approval of 51% of the financial creditors of the CD under section 58B2A. So it has been mentioned. Then after the 51% approvals, he issues a notice to the debtor to make representation. So debtor definitely can make a representation. So he will be allowed 30 days to give his representation. Then these representation will be reviewed by the financial creditors, and then again an approval of 51% is to be required. So post which a resolution professional is appointed. This will see in the amendments to the regulations will definitely come to that. Then after appointment of resolution professional, he would issue for a public announcement, inviting the claims. So this public announcement basically can be challenged by before AA by the CD. Section 58C is saying that moratorium is optional, but the moratorium will be by the AA itself, not automatic. So basically, the RP will have to apply to the adjudicating authority for announcement of moratorium. So there is an option given. So it's not necessary. So for which for moratorium, 51% approval is required. So then timeline for process has been kept at 150 days. So then in this, what can happen is resolution plan can be approved, or if there is no plan or plan is rejected, so they can, or even if the COC decides to convert to CRP, or it can be, there can be withdrawal. Approval of 90% COC is required. So either plan is received, not received, or COC they can decide to convert to CRP or withdrawal. So these four scenarios. आगे चलो. So model timelines that have been given is public announcement within 0 days. That is immediately on his appointment. RP is to give the public announcement. Then claims not 14 days but 7 days here have to be submitted in 7 days by the creditors. Then verification is also to be done in 7 days. So T plus 14. So then is constitution of COC has to be done within 2 days, and adjudicating authority report is to be filed with them. So 16 days gone. Then first COC meeting within 3 days of the filing of this constitution. So notice period is again 5 days. So first COC meeting will happen. So there is a conflict here. So because notice period has been kept on 5 days only, so maybe they'll cover it in regulations. So T plus 19 is the basically but they have to they have considered as the timelines. Then 2 registered valuers within 24 days. Matlab another 6 days are given, 5 days are given post the COC meeting for appointment of 2 valuers. Then Form G within 30 days. So of initiation. So of appointment of RP. Then submission of IM to COC, because why they have decreased these timelines. Firstly, because they definitely want to fasten the process, but also there is a rationale that RP doesn't need to now manage the corporate debtor, so he may be expected to have more time to complete the process on a faster pace. So then, so as 30 days is for invitation, then IM to be given within 45 days, EOI is to be given in 50 days, then PRA list within 55 days. So 5 days have been done out of instead of 10 days. Submission of EOI is 50 days. So Form G 30 days. So that means 20 days for this EOI submission. So we have to see. So then submission of objections to provisional list, again 5 days. So then final list 10 days, but that can be always done earlier. So there's not much to look for in a final list. So then issue of RFRP is in 80 days. That means 10 more days after the final list. Then plans in 90 days. That is 30 days from the date of for submission of the objections. Last date for submission of objections. So after that, 30 days have been given to submit the plan. So then 30 days is for consideration of COC, and within 120 days, it is expected that RP files an application for approval of plan. So 30 days have been given to AA. So 150 days includes approval of plan by the adjudicating authority. Let's go further. Yes, Prasad. Yeah. Supervision of CIRP by resolution professional. So 58E addresses this issue, that the resolution professional shall exercise and perform the following powers and duties during the creditor-initiated insolvency resolution process period in such manner and subject to such conditions as may be specified. So first, I'd like to ask, am I clear? Am I audible? And also my pace, are you okay with it, or should I slow it down? Fine. So everyone is okay.
It's clear, sir.
क्या sir?
Yes,
Okay.
sir.
Thank you, thank you. So we have Mr. Budyal's message. So fine. So let us proceed ahead. So basically, what he has to do is he has to call for submission of claims. RP has to call for submission of claims. That publication is there. Then prepare the information memorandum. Then he has to prepare a report in such form as may be specified, confirming whether the conduct of CIIRP is in accordance with the procedural requirements and that the plan filed along with it complies with the requirements of 29A30, which shall mutandis apply to the proceedings under this chapter. So 29A and 30 is applicable here, all the provisions there. So RP is to certify that along with the filing the report for approval of plan. Then duties referred in clauses A to C of section D and E to J of subsection 2 of 25, which shall also apply to these proceedings. So we can always see that. So then एक बार दिखा दोगे ये 18 में A to C क्या है duties और E to J of 25 2 एक बार खोल दो अगर तुम्हारे है ना खोल दो हाँ. So then powers as referred to in subsection 3 and 4 of section 54F PPIRP shall also apply to these proceedings. He has to file a report and documents with the board as may be specified, perform such other duties as may be specified. So आगे आएगा I think about the board में he has to attend the board meetings. Yeah, that would definitely come. So let us see the provisions of section 18 A to C and 25 to E to J, so which are being applied here. Prasad, are you opening? Yeah. So 18 says A to C, है ना? So collect all the information relating to assets, finances, etc., financial position, business and financial operation, list of assets, other as will be, receive and collate the claims as submitted, then constitute a committee of creditors. ये तो इसका तो इतना ही है. So these are duties only. Otherwise बाकी सारी नहीं है ये सब. So he is not to take control and custody of assets. That is the major thing. He is not to manage the operations, etc., as we have already. So these clauses have been omitted. It may be seen here. आगे चलना नीचे थोड़ा सा इसके नीचे. Yeah. So all this, so custody control and management of affairs has been removed. आगे. Even he has not to perform the duties as may be specified by the board. G is not applicable. So let's see how it goes. So नीचे चलो. Yeah. 25. Let us see 25. Section 25. Section 25 ka it was section 25. Yeah. Of IBC. Yeah. So कौन से नहीं applicable? Clause 2 का E to G is applicable. I think E to G. एक बार दोबारा देखना अपने उसमें which all clauses they say are applicable.
E to J. E to J.
So let us see E to J. E says maintain an updated list of claims, convene and attend the meetings of the COC, prepare information memorandum, invite prospective resolution applicants and who fulfill such criteria as may be laid down by him with approval of COC, having regard to the complexity and scale of operations of the business of the CD and such other conditions as may be specified by the board to submit a plan. Then present all resolution plans at meetings of COC, file application for avoidance of transactions, then such other actions as may be specified. So avoidance applications are to be filed even here. So resolution plans to definitely are there. So but A, B, C, D which are not there is appointment of professionals definitely won't be required. Interim finance not required because he's not to manage the operations. Then a custody and control is not required. Then also he is not to represent the corporate debtor in the judicial proceedings. I can understand. Yeah. So these are the things which are not to be done. Yeah. Let us go further. Again to the presentation. Yes. So 54F, so definitely PPIRP we can understand. So then file such report and documents and then perform such duties as may be specified. Next. Then is 58F. The management of affairs of the CD shall continue to vest in the board of directors. So it has been specifically provided here. And the promoter and personnel of the corporate debtor shall provide relevant information related to CD for preparation of the IM to the RP in such form and manner within such period as may be specified, and where any such person has sustained loss or damage as a consequence of omission of any material information or inclusion of any misleading information or false information provided by such person, they shall be liable in this regard. Then is 58H, which says CIRP may be converted to normal CRP. So specifically provided either by NCLT if no plan is received for approval, or if the CD or its personnel fail to assist or cooperate. So even if they fail to assist or cooperate or plan is rejected, it will be converted to CRP process. So it is very clearly provided. Or 58H, there has been given alternate that if the COC by a vote of not less than 66% of the share resolves to convert the CIRP to CIRP in respect of CD, the RP shall make an application for this purpose to adjudicating authority. So either in the situation plan is not received, so or it is rejected, or in the situation that COC itself wants it to be converted to normal CRP by a vote of 66%, the adjudicating authority may order accordingly. So in any case, we have to approach adjudicating authority. Then 58I says the adjudicating authority may allow the withdrawal of public announcement made under subsection 4 of section 58B and close the CIRP resolution process on an application made by RP with the approval of 90%. So 12A is given here now. So voting share of COC except before constitution. And same thing, as has been done in CRP, that now 12-way withdrawal is possible only if it is before so only if it is after the constitution of COC or before the first invitation of resolution plans. So that means only, I think, 15 days window will be there, or 11 days window from 19th day when the COC is formed till 30th day when the expression of interest is invited. So 11-12 days window will be there. However, in my understanding, so this is for the filing of initiation of the withdrawal process, because that is given in the regulations how it is to be initiated. However, so just a request has to be made within this period by the promoters to settle it and for settlement, etc. And because it is not by the applicant, so the RP is to file. So I hope it is that 11 days, if the person submits the request that he wishes, he gives his intent within this period, so that will be okay, even in CRP, even here. So that period between the constitution of COC and first invitation, so request for the initiation of the process, withdrawal process shall be done. Whatever initiation has been prescribed in the code or regulations, so that initiation has to occur between that period of COC constitution and first invitation. So 58J says, so where COC by vote of not less than 66% of voting share approves the plan in accordance with 30, the RP shall submit such approved plan to adjudicating authority with the report referred in 58EC1 1C. So we have already studied that report. Next. So COC approval is by 66% here. So let us take up now the discussion paper. So because the regulations are given there. Yeah. So this is for the regulations. So let us come to code. थोड़ा सा बढ़ा देना इसका size. Yeah. Yes. So proposed amendments, definition. So in the definition, the applicant means a financial creditor belonging to class of financial institution notified under 58B1 seeking to initiate CRP. So notification for financial institutions will be done. So eligible financial creditors will mean the eligible financial creditors of CD notified. Again, it is to be notified. Then unless the context otherwise requires, word or expression used and not defined in these regulations but defined in code or IBBI regulations shall have the same meanings. Then meetings and communication. The meeting shall be convened in physical mode, provided that where it is not practicable to hold the meetings in physical mode, the committee may permit the meeting to be conducted in electronic mode. So basically, primarily it is required to be conducted in physical mode. So this is something new. Then communication under these regulations shall, as far as practical, be made through electronic means. Okay. So no paper use, but meetings physical. Then notice of intent to initiate the CIRP is to be sent to all other eligible financial creditors. So this is in the case it is a consortium advance or multiple lending. So there the financial creditor, for the purpose of determining the existence and value of financial debt owed to the eligible financial creditors, the applicant or its authorized representative shall prepare the list of eligible financial creditors as on the last date of the month immediately preceding the month in which the applicant intends to initiate the process based on the records available with the IU. So they have to prepare the list. The applicant has to prepare the list of the eligible financial creditors as on the last date of the month, preceding month. So fine. Then provided that where such data is not available with the IU, the applicant may prepare such list from other available sources. Upon preparation of the list of eligible financial creditors under subregulation 1, the applicant or its authorized representative shall convene the meeting of all eligible creditors for the purpose of obtaining approval for initiation, like it was specified there. So approval of 51%. So the applicant or its authorized representative shall issue of notice of meeting to all eligible financial creditors in such form as notified by the board by giving not less than 15 days time to the participants. Manner of obtaining approval, the FC intending to initiate CIRP shall obtain approval of at least 51% of the value of debt to such eligible financial creditors. The resolution approving for initiation of the process shall be recorded in writing. So basically 51%, not of all financial creditors, but only of the eligible financial creditors who are eligible to initiate the process. Save as otherwise provided, the provision of subregulation Regulation 26 of IBBI CRP regulations shall applicable mutatis mutandis as context may require. Intimation to the corporate debtor. For the purpose of clause B2, section 58B2B, the applicant or its authorized representative shall duly serve a notice in such form as notified by the board through circular to the CD intimating the intention to initiate. After approval, notice is to be issued to the CD. Yes. So then representation. So the CD may submit a representation in writing to the applicant or its authorized representative within the period of 30 days from the date of receipt of the notice, where the applicant, after consideration of the representation received, continues to pursue the initiation of CIRP under 58(2)(b, it shall obtain. So again, there is an approval of 51% in value of debt to eligible for, if they want to continue further. That means appointment of RP is again requires 51% approval. So after obtaining approval under 7(2) sub-regulation 7(2), regulation 7 sub-regulation 2, the applicant shall within 3 days appoint an IP, preferably an IPE. Here, the IPs are being brought in first time for there is a recommendation in the regulations itself that IPs be appointed as RP after obtaining approval of eligible financial creditors, provided that no disciplinary proceedings are pending against such an IP and the consent of IP is obtained in such form as may be notified. Commencement. So commencement is basically by appointment of the RP, and he firstly does is on the same day of appointment issues a public announcement. So upon appointment, the RP under 58(b)(3 shall immediately make a public announcement in such form as will be notified within 3 days of his appointment. So in the model timelines, it was 0 day, but still 3 days gap has been provided here. So save as otherwise provided under this regulation, the provisions of IBBI CRP regulations regulation 6 shall be applicable for public announcement. Fine. Then reporting to adjudicating authority and the board, the RP within 3 days of public announcement submit to the adjudicating authority and the board an intimation of initiation of CRP under such form as notified by the board through circular, along with a copy of it is very strange, that through a form to be provided by the board, adjudicating authority is to be intimated, not by way of an application, because there will not be any CP for this matter. So we'll see how it comes later on, along with a copy of public announcement and resolution approved under regulation 5. A report confirming compliance of 58B and 58A and B of the code, including verification of the existence of the amount of default, that it should be checked in the IU. Then proof of financial debt and status of applicant as a financial creditor. So then such other relevant information as will be notified by the board. So the resolution professional shall also file such report and forms. So everywhere you will see that circular is mentioned, because all the forms have been taken away from the regulations and have been brought in as circulars. So the RP shall file such report forms along with enclosures thereto as will be notified through circular. Then removal and replacement. Where at any time during CIRP the COC by 66% of the opinion that RP shall be replaced, he will be replaced after obtaining the consent through circular, provided that no disciplinary proceedings are pending. So provided further that where COC has not been constituted, the eligible FCs by a vote of not less than 51% in value due to such shall decide to replace. So even before constitution of COC, so that RP may be replaced by 51% by the eligible financial creditors. Upon replacement, the IP appointed as RP shall intimate the adjudicating authority and the board regarding the removal and replacement under subregulation 1. So newly appointed RP is to again inform about his appointment. Then filing of objections. For the purpose of 58C1, the CD may file an application to AA in such forms. The application shall be duly signed. So this is about appointment of the RP, means the initiation of this process can be challenged by the CD before adjudicating authority. So he is to sign this affidavits, etc. So the RP after obtaining, so it is up to AA then. So what they do after getting this application, they may stay the process or they may let it continue after seeing the prima facie. So whatever is to be done, AA will look into it. Then moratorium. The RP after obtaining approval of not less than, so again an approval of COC 51% for and an application is to be made to AA for declaration of moratorium in accordance with 58G. Provided that where COC has not been constituted, such application shall be obtained by filed after obtaining 51% of the financial creditors approval. So that is better. I think on the day of his appointment, he may take first thing he should do this. So because if there is no moratorium, so the CD may do away with these assets, etc. So there may be many issues, withdrawals by etc. and all those things. So moratorium should be got initiated. Yes, so the RP shall make a public announcement of the commencement of moratorium immediately on filing of application. In such, so moratorium commences on the filing of application, not on the orders. So as soon as he files, so 0th day, or I think there should be a provision in the public announcement also that so moratorium, if in case has been done, so one public announcement shall be sufficient. We'll give this comments to IBBI, though the window is closed, but this would be better that if in a single public announcement, moratorium if has been commenced and application filed on the 0 day or within 3 days, so it could be given in the same public announcement. So where adjudicating authority rejects the application, then there is another public announcement. So fine, otherwise on so everything everywhere they know that if the moratorium application is filed, it will take another it can take another some time. So definitely they have been well informed of this, so they have taken this decision that let it be automatic. So on filing of application, so constitution of the committee, so report is to be filed within 2 days after the verification of claims. RP shall convene the first meeting of COC within 3 days of filing his report. Aage. Then save as otherwise. So the regulations are 18 of CIRP regarding the meetings or constitution of the committee will apply. Yeah. Then is in IM. The promoter and personnel of the corporate debtor shall provide all details to the CD as sought by the RP after creditor initiated process commences. All details relating to CD are to be provided to the RP. So by the personnel, so that has been mandated here also. RP shall, so instead of section 19, it is here. So in the regulations. So while there is in the code also certain provisions, yeah. So RP shall prepare and submit the information memorandum in electronic form to each member of committee within 45 days of commencement of CIRP. The provisions of 36 regulation 36 2 3 3A 4 and of IBBI CRP regulations will apply here too. Management during the process. The corporate debtor shall manage the affairs of corporate debtor in a manner not prejudicial to the creditors of the corporate debtor or in a fraudulent manner. So, corporate debtor shall manage means all the personnel of the corporate debtor who must have been, already managing the affairs. So, those personnel will keep on managing. So, the CD shall not undertake any of the following actions without approval of the committee. Transaction above a threshold. So transactions may require approval of the COC. So any other matter which COC may decide and not covered under section 28. Okay, so those matters also can be, the CD can be restricted. So the CD shall provide the following details having material. So section 28 is also applicable. That means, so besides that, if anything else is to be done, so that would be require an approval. So COC can prescribe those items where approval of COC will be required by the corporate debtor in business. The corporate debtor shall provide the following details having material impact of the on the business of the CD to the RP, details of legal proceedings, key contracts, and other information which the RP or COC may ask. RP shall exercise powers under 54F 3 and 4 to include the following: call for information related to operations of CD, including payments made, visit the premises of the corporator, inspect the assets of CD, call for information related to compliances applicable to the corporator and its status. आगे प्रसाद, हाँ, yeah. The RP shall attend meetings of the members, board of directors, and committee of directors or partners of the CD as the case may be, and shall have the right to reject any resolutions passed in these meetings with reasons to be recorded in writing. So this is what was required basically. So because if they go on passing the resolutions, so they can definitely, and moratorium is not there, they can go for sale of assets or whatever, they can do the entire things which they want. So this has been brought in to safeguard that. So the resolution plan, the RP shall publish brief particulars of the invitation of EOI in such form as may be notified by the board through circular at the earliest, not later than 50th day from the insolvency commencement date, from interested and eligible RAs to submit the plan. Though it was given 30 days, here it is not later than 50th day. So these things will be maybe rectified when they finally bring in the regulations. So the request for resolution plan shall allow the PRAs a minimum of 15 days to submit the plan. So there it was 30 days to submit the plan. So let's see how it comes later. The committee shall use a challenge mechanism at any stage, which is now also. So then save as otherwise provided the provision of 36A, 36B, C, 37, 38, 39 regulations of CIRP regulations are applicable. CIRP costs. So CIRP cost shall mean the fee payable to the RP and authorized representatives, any expenses incurred by RP for discharge of his functions as approved by the committee, then fee payable to the board under 31A regulation of CRP regulations, then any other costs relating to the process and approved by the committee, then RP shall place in each meeting and seek approval for all costs which are part of CIARP. Withdrawal. An application for withdrawal of CIRP under section 58I shall mean in such form as notified by the board through circular and shall be accompanied by bank guarantee towards expenses incurred for conducting the CIRP till the date of filing of withdrawal application. So who will be giving, that is not mentioned. So that is to be seen how it comes. Who is to give this application? The applicant only, or who will be giving the bank guarantee? So basically the applicant. The applicant must be required to give the application and through the RP, and along with that bank guarantee will be given by the applicant. Chalo. So certain regulations have been specified that these are applicable. These are to be read like this. Then basically 150th day to 15th day to be read as so. It is basically certain changes which are here in the between CIRP and CIRP. So those have been given here. Then conversion to CRP. For the purpose of 58H2, where COC at any time during the CIRP by a vote of not less than 66% resolves to convert CIRP into CRP, the RP shall make an application to AA in this regard within 3 days of the resolution passed by the COC. Model timelines are like this, which we have already seen. Representation 30 days, second approval time allotted to FC 30 days, and appointment of RPA and RP to make announcement A plus 3 is equal to 2. Okay, T. So T basically is on the date of public announcement. So initiation of CRP is taken from the date of public announcement. So appointment of RP has been marked as A. So 30 days time is for the second approval. So first approval being taken with 51% and notice issued. From the issuance of notice, 30 days. Then after representation is received, 30 days time is allowed for appointment of RP to the FC. 30 days have been allowed to take another approval for appointment of RP. So then RP is appointed on A, for timelines A, then A plus 3 on public announcement. T has been is the date of initiation of commencement of CIRP. So all this we have already said, read. आगे चलते हैं. बस let's move further. So we can take up questions regarding CIRP. एक बार साथ साथ ही कर लेते हैं. So if there are any questions, so that can be taken up. Because इसमें सारे जो हम आगे डिस्कशन करेंगे सब अलग अलग है. So we can take up the questions regarding CIRP. Any questions, or you are all clear about it?
In this resolution plan submitted, this present promoters have any right to match the best resolution plan?
Not like PPIRP or something like that. It is basically same 29A is applicable, so they can also submit if it is an MSME. So till now, because there is not much clarity, but it seems like that 29A, if they are eligible, they can definitely submit their plan. And
but they don't have right to match the base plan.
So no right to match is not specifically provided, and it should not be provided also. So because then it will entire purpose is gone. Nobody is going to give the plans just to get another person's things resolved. So no other person will give plan like that. I don't think it will come. So it's not there, but I am not hopeful that such kind of provision will be there. Yeah. Anything else? Anything regarding CIRP? Any questions? So fine, that means I have been able to explain so nicely. So everyone has understood. That's very nice. So let's go further. So the next is amendments with respect to personal guarantors. Yeah. So let us take up the amendments. So basically, major most amendment is removal of the entry moratorium. So section 96, which was being misutilized to a very huge extent, on filing of application there was a moratorium for recovery. So which has definitely this provisions were being used by certain persons just to bypass, to restrain the recoveries and keeping the application pending, but by this way or that way. So for a longer times. So this provision has been now removed. There is no entry moratorium now on application filing. A moratorium will be only the final moratorium under 101. Otherwise, no moratorium, entry moratorium is there. So that has been removed. Then timeline extension of RP examination timeline for filing of report from 10 days to 21 days. So we were facing this problem. Section 99 report, we were being allowed only 10 days time, so which has been now increased to 21 days. Then mandatory creditors meeting has been introduced. So we'll take up how it is being done. Then consequences for non-submission of plan, that is also very nicely taken up, that if within 21 days of the last date for claims, so the immediately the RP is entitled to file the closure application. So we'll take up that also. Then comprehensive asset disclosure, regulation 6A has been introduced, including beneficial and digital assets. So this asset disclosure is a very major thing. In one of my matters, the entire CARP of that corporate debtor was concluded with a resolution plan of say 20-25 crores. And when I came in, I got an assets of around 15 crores of value, mortgage to the creditors. So which I disposed of for 27 crores. But when I traced the assets, and a borrower was saying he doesn't have any other assets. But when asset tracing was done, so assets of to the tune of 850 crores have been traced. So this asset disclosure is very major element, and it is really going to become a very major process, asset tracing in Indian insolvency regime, because foreign countries this asset tracing is very much stressed upon. So now we are getting it done even during PIRP. That in my process, the person has given the repayment plan, and CUC has asked me to get it asset tracing done during PRP to see that he has disclosed the assets rightly, just and so that the plan may be considered accordingly. So this is a new concept. So asset tracing is going to be a another big field for the professionals. So then coordination with the corporate debtor CRP. There is a provision for that too now. So forms have been shifted to circulars, as I have already informed you that now regulations may say they have removed the forms. So this will come in the shape of circulars. Yeah. Let us take up the provisions. So additions have been made to section 106, where no repayment plan is submitted within the period stipulated under subsection 1, because I think section 96 has already deleted, so we don't so there is nothing about that. So we are starting from 106 only. So the RP shall submit a report to the adjudicating authority, and adjudicating authority shall pass an order terminating the insolvency resolution process of the debtor, and the debtor or creditors shall be entitled to file application of bankruptcy under chapter 4. So this was not clear earlier. So they say now within 21 days of the claim submission, if no plan is received, so he will submit the report to AA under 106 only. So otherwise we were confused, do we have to submit the report under 106 or 112? So it has been clarified now that in 106 only you can submit a report to the AA, and AA will pass an order of terminating this IRP process, and the creditor will be entitled to file a bankruptcy application. Notwithstanding anything to the contrary contained in the provisions of subsection 3, subsection 2, both subsections. So where the repayment plan is in respect of the debtor, who is a personal guarantor to the corporate debtor, the RP shall summon the meeting of creditors by issuing notice, where therein the date, place, time, and place of such, specifying the date, time, and place of such meeting. So fine, the meeting is compulsory now. Earlier, there was provision was under regulation, so it is now come under the code. So let us go further. So basically, if the plan is not submitted, then only he has to, then also he has to have a meeting. So then comparative. So regulation 6A, which is a new provision, it says detailed statement of assets required: direct, indirect, beneficial, global, digital, and contingent. So basically earlier there was no disclosure as such. So now there is a disclosure requirement. So enhances this transparency and reduces concealment of assets. So then regulation 11A is also new, which says approval of creditors for asset transfer to CD. So that is linked with the CRP process. So approval of creditors would be required if the PIRP is going on. So regulation 11A has been brought in here. So it protects the interest of the creditors. So basically creditors may approve the transfer of the assets to the CD where CRP is going on. So forms A, B, C have been shifted to circulars. Then section 121, explicit provision for filing bankruptcy after termination of resolution. So there was earlier ambiguity. So now it has been cleared that there is a provision under section 121 that bankruptcy will trigger. Then section 124 entry moratorium has been removed from bankruptcy also. Okay, so it is now creditor consistent and friendly. Creditor friendly approaches have been done. Consistent creditor friendly approaches. Yeah. Yes, Prasad. So then section 96 has been removed. Entry moratorium is not there. Section 99 timelines have been extended to 21 days. Section 106 specific consequences introduced for non-submission. So like we have just read that RP will call a meeting and then he will file the termination of the process before AA, and the creditors will immediately get the rights to file bankruptcy. So the processes, the lengthy process earlier has been shortened to a great extent. So creditors meeting mandatory has been introduced now. So it will strengthen the creditors participation and control. Section 28 has been provided, wherein mandatory coordination between the RP of the PG and RP of CD. So this was earlier, a problematic area, that the RP of the CD did not provide informations to the RP of the PG. So that has been now, introduced. Because of group insolvency also it was required. Asset alignment can be done also, because now there are many linkages between CRP and personal insolvency. So there to smoothen those processes. So basically 28A has been brought in. So there should be mandatory coordination between both the RPs. Yes. Now we'll take up the discussion paper. Yes, Prasad. Yes. Hmm. Okay. Okay. Hmm. Yes. So these will be called, okay, these are definitely personal guarantor. थोड़ा बड़ा ही रहने दो. So basically what they say is, so statement of assets in regulation 6A, that for the purpose of section 94 and 95, along with the application for initiating the insolvency resolution process, a complete and true statement of all assets including the following with supporting evidences shall also be submitted. So that in the beginning 94 is by the debtor, but 95 maybe the bank, whatever they have, the creditors have the information, they may submit along with the application. But so there is whatever is the cash in hand, balance in the bank accounts, and any kind of instruments available, business interest and commercial assets. So any ownership, whether sole or joint proprietorship, partnership, or limited partnership, or any associated assets of those businesses, inventory, plant and machinery, tools of trade, professional equipment and goodwill. So these all to be declared along with the application. ऊपर चलो थोड़ा सा. Investments, हाँ. Yeah, no. Yes. Investments, domestic and overseas. Investment in shares, etc., wherever are there. Immovable properties. Then any funds are there for provident fund, gratuity, etc. Digital assets, cryptocurrencies, and all these things. Then intellectual properties, then valuable movable assets, agricultural assets, basically everything owned by him. Receivables and advances, claims and contingent assets, ESOPs, etc. So whatever are available. So here they say, provided for section 95, creditor shall file information relating to assets of the individual to the extent available. Like I was saying, because 95 is by the creditor, so basically whatever is available. But for 94, it is necessarily compulsorily to be filed with an affidavit, so that tomorrow he cannot back out that he doesn't have this asset. So statement shall mandatorily include assets owned directly or indirectly, whether in the name of individual or otherwise, assets held individually or jointly with any other person, assets held in fiduciary capacity as a trustee, guardian, executor, or partner, assets held through beneficial ownership structure, including the trusts, partnerships, companies, HUFs, or any other arrangement conferring beneficial interest or control, any assets over which the individual exercises control, influence, or derives economic benefits, irrespective of the legal title. Oh, nice. So wherever he has any control, so those assets he has to, even if there is no title, if he is occupying possession, or he is having some asset on lease or anything, that also has to be declared. So form B, etc. So all this to ठीक है. So then these have been brought into circular. Then subsection 3A shall be instructed in sub-regulation 3. Fine. So facilitation of transfer of assets. So the provision has been given here, So because in any case, if the CRP of CD is going on, and there is a requirement of transferring some assets of the personal guarantor to that CRP process. So in that case, if the PIRP is also going on, there is a requirement of coordination between both the RPs, and here the process is also provided that how the transfer will happen, where the debtor is a personal guarantor who is undergoing an insolvency resolution process. The RP of such debtor which has given the personal guarantee shall coordinate with the RP of the CD in respect of whom the guarantee has been given regarding transfer of the asset in CRP of the CD in respect of whom such guarantee has been given for the purposes of section 28A. So 28A provides for transfer of the assets. So both the RPs will coordinate. So for 28A, the RP shall obtain approval from the creditors which has given the personal guarantee. Yeah, so creditors' approval is definitely required. So then where approval is granted, the meeting of creditors permitting the transfer, the RP shall ensure that the proposed transfer is appropriately disclosed in the report of 106 and 112. So there, this has to come in the report that such and such asset has been transferred to the CD. So next, इससे थोड़ा आगे चलना. Yeah. Okay. So only these are the changes in the regulations, है ना? नहीं है. No, I think no. नीचे आओ देखिए. Is there anything else? No. That's all. So that's all in the personal guarantor scope. So these are the amendments there. So let's go further. So in the bankruptcy, so that was in PIRP. So in the bankruptcy process, so what is the amended provision? That is under section 164A, transactions defrauding the creditors. So basically, 66, there was some miss in the earlier bankruptcy processes. So there was not a provision equivalent to 66, which is there in the CRP processes. So now 164A has been brought in, that where the debtor has entered into an undervalued transaction as per 164(6) and AA is satisfied that such transaction was deliberately entered into by such debtor for keeping its assets beyond the reach of any person who is entitled to make the claim against the debtor, or in order to adversely affect the interest of such person in relation to the claim, the AA shall make an order restoring the position as it existed before such transaction, as if the transaction has not been entered, protecting the interest of the persons who are victims of the such transactions, provided that an order under this section shall not affect the interest on property which was acquired from a person other than the debtor or his associates, as the case may be, and was acquired in good faith for value and without notice of the relevant circle. So genuine transactions have been protected. So or affect any interest deriving from such an interest. shall not require a person who has received a benefit from transaction in good faith for value and without notice of the relevant circumstance to pay any sum unless he was party to the transaction. Again, party to the transaction. So then 178 is there, priority of payment of debts. So for removal of doubts, it is clarified that any amount, whether or not a security interest is created to secure such amount by an act of two or more parties or by mere operation of law due to the central government or state government in respect of the whole or part of the period of 2 years preceding the bankruptcy commencement, shall be distributed under this clause, and any remaining amount, whether or not such security interest is created to secure the amount due to the central government, shall be distributed under clause E. So basically, rainbow judgment. So this is, to priority of payment. It has been clarified here also about the security interest. So by operation of law. So then 183A has been inserted, which says if any person has initiated a frivolous or vexatious proceedings before AA under this part, it may impose upon such person a penalty which shall not be less than 1 lakh, but which will extend up to 2 crores. So this clause may be used for whatever has been done till now, you know. So definitely there are very many frivolous proceedings just to for the moratorium purpose. Later on, I don't think, because there will not be any moratorium, so the person will not gain that much. So आगे चलो. So direct bankruptcy of the estate of deceased without PIRP. See, what happened is now I have a case law, practical case law, just recently. So what has happened, because PIRP was not being allowed against a deceased. So what I did in one of the matter is, so I filed an application under section 95 on behalf of a creditor, and wherein we filed the application against the estate of the deceased and through its legal heirs, because in my view, the estate, definitely if it is being enjoyed by the legal heirs, so the estate is liable for the debts also, the guarantees given, and so accordingly I filed this application. And my logic was, otherwise even because bankruptcy has a provision for the estate, but the enabling provision for bankruptcy directly without PIRP is not there. So now it has been brought in. So my case, already we have got the orders as appointment, my appointment as RP against the estate of the deceased in Eastern Silk, personal guarantors of Eastern Silk matter. I have been appointed as RP against the estate of the deceased through legal heirs. So which is a landmark judgment. So already, because to enable that we can go in bankruptcy proceedings, so we got this done, and we represented before the AA. So we got these orders. So so now this has been clearly addressed here also, that direct bankruptcy of the estate can be done. So continuance of proceedings on death of bankrupt. If a bankrupt dies, the bankruptcy proceedings shall continue as. So here also, this is not there is not very clear provision for initiation. So however, in any case, with this, the AA may directly initiate bankruptcy. So basically, bankers shall continue. That shall be initiated also. It can be read like that. Maybe some judgment of Supreme Court may be required, or some judgment of NCLET. So administration of estate of deceased bankrupt. So provisions of Chapter 5 relating to the administration and distribution of estate of the bankrupt shall, so far as may be applicable, apply to the administration of the estate of the deceased bankrupt. Right. So similarly, the administration will be done by the bankruptcy trustee. So issues remaining to be addressed. So direct bankruptcy of his estate without PIRP. Section 121 says that an application for bankruptcy may be filed when the adjudicating authority has passed an order under Section 100, subsection 4, application under section 94-95 is rejected if application was made with the intention to defraud its creditors or the RP. And section 1152 provides that where repayment plan is rejected, and 1183 provides the repayment plan not implemented, the bankruptcy application must. So these are the present provisions. So there is no enabling provision in the code to address the direct bankruptcy of the estate of the deceased personal guarantor, leaving the creditors without the remedy available. So as I have already said, so we got this done. But in any case, now with this new provision about the continuation of bankruptcy, so that may be read as initiation also. So that initiation may be done. So that is definitely, I am hopeful, very hopeful that we may be able to get favorable orders for reading continuation as initiation also. So otherwise, as I have told you, we got ourselves appointed as a bankruptcy or this resolution professional for the state of bankruptcy. So we can go through this route also, which is existing route. Then otherwise, we will also, if there will be any issue regarding that, we'll try this new provision and see. So this is the matter where I have been appointed. So report, so status is that report has been filed, recommended the approval of section 95 against the. Can you show the order? Yeah, this is the order sheet. So estate of late Sham Sundar Shah. This order, this application was filed. So registry is directed to issue notice upon personal guarantor, proof of service is so and so, service of affidavits, application. So notice has been issued. So yeah, so appointment is to be so they have appointed for filing of report under 99 in the meantime. So RP Anil Kohli is appointed as RP in exercise of section 97 power. The resolution professional is directed to file declaration within 7 days from the date of receiving this order to the effect that he fulfills all the requirements for being appointed. RP will be paid remuneration of 50,000 and registry is placed. Yeah, this is, I read it first time 50,000. How can they say? So, chalo, we'll see. Registry is directed to issue notice forthwith to the RP and the personal guarantor by way of speed post and by email and placed by the tracking information on record. Learned Counsel for Financial Creditor is directed to serve a copy of petition along with copy by all available modes and so and so. RP shall file the report under 99 within 10 days and serve upon personal guarantor, corporate debtor, as well as financial creditor. So basically, this is there. So in against the state, this is first time an order. So RP appointment and filing of the report of 99. So let's see how it goes further, because definitely there will be opposition to this. Notice has been issued. So in the meantime, at least some movement is there. So we'll see next. So I gave this notice. Let me show you that notice, how it started. We gave the notice to the guarantors. So invocation of guarantee notice. So we issued like this. See, to the state of so and so, subject invocation of personal guarantee executed by you in favor of so and so and as sanction to Eastern Silk, sanction and default, Allahabad Bank Consortium like this, or all to Eastern Silk, so and so. So, आगे चलो. Execution, default, surface, demand and invocation. So we hereby invoke the guarantee and call upon you in the capacity of legal heirs of the deceased guarantors to pay to the undersigned from the estate of the deceased. So basically, we are not personally implicating the persons, but we have specifically mentioned that pay from the estate, because when they are enjoying the estate, so to make our point before the court that this is not against them who are not guarantors, it is against the estate which has passed on to them by virtue of the law. So the state in any case is liable. So from that state they have been asked to make good the guarantee. So failure to comply. So before the appropriate forum, we are already there. So this way it was issued. So very consciously drafted, and very it was an innovative thought that we try this way of getting Ajo. So one of the legal year has also expired. So we sent to his wife. Shall now. So any questions regarding the personal insolvency or bankruptcy? No questions? Everybody is clear? So nice. So we can proceed further then. Chaliye. Let us proceed further. Introduction of the group insolvency. So group insolvency, though through the way of judgments, etc., has been getting implemented in some case to case basis, and there was a judgment of Supreme Court in Mansi Barar where they say that yes, project wise this should be done and not for the entire CD. So in many cases, so these things, this group has been insolvency has been discussed. So now the provisions of law has been enabling provisions have been provided in the law for initiation of group insolvency. So under section 59A, so power to make rules for initiating the proceedings for coordination and cooperation of the corporate debtors of the group. So basically, now this power has been given for making of rules to initiate the proceedings for the group. So basically, a coordination and cooperation of the CDs of group. So it has been named like this. So separate treatments of the companies under existing IBC. Each company is treated as so independent legal entity. Fine. Separate CRP liquidation proceedings are required. Corporate groups, so presently this is the status. So corporate groups often operate as integrated businesses, which leads to fragmented resolutions, inconsistent decisions, and loss of enterprise value. So basically, these are the issues, and practical difficulties are being faced in the insolvency proceedings separately if the companies are interconnected. We have seen this in many of our cases, including Moser where there are numerous, group companies. So we have seen that this issue comes in where, where there are group companies and many transactions do require that if they had been together, so that would have made the things very easier. So integrated connected corporate structures basically usually observe that they have common promoters, management, shared assets and operations. In most of the cases where large groups are there, they have common office, common staff also, and looking into, one person is looking into 10 companies of the group. So it becomes difficult to name that he is for our CD. Is he responsible to provide us the information, because he will say I am not on the your roles, I am in the roles of another company, but he was the person who was looking for on and to the affairs of the CD of whom you are appointed as RP. So there were very great difficulties, and we are still facing GVK, Moser Bear, certain group companies we have seen wherein large structures are there, and the registered office, it is owned by some of the one of the person, one of the entity of the group, and or the personal guarantor, or the one of the entity, and the entire group companies are operating without having any formal arrangement of lease, etc. So you are not able to assert your right to enter into that premises. In one of my matter, what happened is, I was an RP and there was another RP of the group company. So registered office, all the registered offices were operating from that premises, and which was owned by the RP, the company which of which the other RP was there. So he closed the doors when we visited to take the files. He closed the doors and he did not allow us entry, saying that since it is owned by another company, so how do you get the right? I said it is my registered office is also here, but he says there is no arrangement. I will not allow. I had to approach IBBI, to get their indulgence and get him, kind of some kind of direction, or maybe I should say informally, but somehow, because some people are there who can take advantage of such situations. So promoters definitely do take, but even the RPs, I am telling you, do take such kind of steps under influence from maybe whatever. So there are intercompany guarantees also, so that some of the assets have been mortgaged with this, and also the dual claims issue comes in, where there are corporate guarantees. So basically, the claim for the original is also there borrowing, then for the corporate guarantees. So these kinds of things. Then common financing arrangements, as I have said, the same thing. So these things make it very difficult to conduct the CARPs separately for all the entities. So to address that, so even the failure of one of the entity impacts the other company group companies. So let's go further. So value erosion was there because there was the operational synergies were being destroyed due to separate insolvency proceedings. Overall business value was reduced, and integrated operations were commercially unviable. So like manufacturing, logistics, this also happened. Sometimes they are one of the companies into production, another is in logistics, another is distribution. So how to manage those things, so because under one promoter they were doing fine, it was a streamline. But if only one company comes to you, which is say into logistics, and the promoter is handling the other operations through different entities, so you will definitely get a great problems in running the entity which you have been appointed as RP. So there is a huge issue in that. So everyone is aware that these issues are there. So multiplicity of proceedings, litigations. So related entities, different NCLT benches may be there. Separate COC sometimes takes conflicting decisions, which may not be very cordial for or beneficial for the interest of stakeholders of all the group entities taken together. So multiple insolvency professional adopt different strategies also, as I have told you, one of the instance. Then it leads to delay, increased cost, duplication of efforts. Aage. So resolution plans is the most difficult things in the separate entity which is having not having sometimes some entities do not have any standalone operations, so they have interconnected operations. So resolution plan, getting a resolution plan for separate entity separately, definitely, because if one of the entity is taken by some of the RA, so it will not solve his purpose if he doesn't get the other entity on which this entity is dependent for business. So it makes consolidated bidding difficult. Also, group restructuring is difficult. Then coordinated resolution plans are difficult to implement. So basically, overlapping of assets is there, common creditors in some of the companies, like I faced in Moser Beer also. So there were different entities, Helios and Moser Beer Solar, then Moser Beer India, which I was the liquidator. So intercompany transactions, and even creditors. The issue was like some of the land they were using jointly, so the creditors of different companies were taking different different kind of decisions. So I had to adopt some strategy wherein at least for my corporate debtor I did the best and got it in a very good situation. He was benefited very nicely with that. So you have to then do that way. Otherwise, if it had been together, so more value could have been realized. Yeah. आगे. So now 59A, which is the provision for enabling provision for group insolvency framework, it says, notwithstanding anything to the contrary contained in this code. So basically, it is a overriding clause. So the central government may prescribe the manner and conditions for conducting insolvency proceedings under Part 2, where these proceedings are initiated against two or more corporate debtors that form part of a group. So basically, it is when there are two insolvency proceedings and both should have been initiated, or both or more, whatever. So then they are part of the group. In that case, central government can prescribe the manner and conditions for conducting insolvency proceedings. So it's not that you can bring in all the group as such. So if the proceedings are being initiated for these, then only this will be applicable. So not that just due to this provision you cannot bring in the company which is not defaulted under. So that cannot be brought in just because being of that group cannot be brought under insolvency. So it has to be, all have to separately pass the test of default, and the insolvency proceedings have to be initiated against all who are needed to be brought in under that group insolvency. So, without prejudice to the generality of the foregoing provisions, such rules may provide for or all or any of the following matters. What is a common bench for the insolvency proceeding for the corporate debtors that form part of a group, and the manner of the transfer of pending proceedings of such corporate debtors to such bench, and for proceedings under the rules made thereunder under this section. Then coordination between the insolvency proceedings of the corporate debtors that form part of a group, including the coordination between their COC and IRPs, RPs, or the liquidators. Replacement appointment of a common resolution professional to facilitate coordination between insolvency proceedings. So common IP, this is one thing which is interesting. So for the group companies, common IP can be appointed. Then formation of a committee comprising of the committee of creditors, so two of the corporate debtors. So there can be a super committee which can have the all the COCs of the corporate debtors under that group. Then making of an agreement that provides measures to coordinate and synchronize with different aspects of insolvency proceedings of the corporate debtors that form part of the group, which shall be binding on the corporate debtors approving the same, including their committee of creditors, AA. The AA may issue necessary orders to implement the approved agreement. Treatment of costs incurred for taking measures to coordinate the insolvency proceedings of the corporate debtor that form part of the group. So costs can also be taken up together. Aage. The rules made under this section may provide that any of the provisions of the code shall apply with such modifications as may be required to administer and implement the provisions of this section. For the purpose of this chapter, the expressions control includes the right to appoint majority of directors or other key managerial personnel entitled to manage the affairs of the corporate debtor, or to control the management or policy decisions
exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of their shareholding, so and so, or in any other manner. Group means two or more CDs that are interconnected by control or significant ownership and include holding subsidiary associate companies. Insolvency means proceedings like CRP or liquidation. Significant ownership includes right to exercise 26%. Okay. Notwithstanding anything contained in section 241, a draft of every rule proposed to be issued under this section shall be laid before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, or if both houses agree in disapproving to the issue of rule, or both houses agree in making modification of the rule shall not be notified or shall be notified only in modified form as may be agreed. So these rules are to be again, approved by the parliaments. The period of 30 days I referred to in subsection 4 shall not include the period in which the house referred to in subsection 4 is prorogued or adjourned for more than 4 consecutive days. Every rule notified under this section shall be laid as soon as possible after it is made to before each House of Parliament. Aage. So basically, in cross border, regarding the plans also, the resolution plans. So since an agreement can be arrived at and the COCs may coordinate, single IP may be issued, though there is no specific provision as to a resolution plan. However, it will be covered under the provisions which say that the manner in which the insolvency proceedings of both the all the entities or both the entities are to be conducted can be prescribed. So basically, this may be covered under that provision. So though I would say rules will only make it more effective, because for now, till the time rule is not there, these are only enabling provisions. So rules may include more things. These provisions will enable the making of those rules. So I think rules have not been yet prepared. I have no draft has also been circulated. So we have to wait for that. So anything to be discussed regarding that, because this is for all of us. It's something very new. Any issue which or somebody has some better knowledge about this can also share their perspective about group insolvency. So if they have dwelled more into this issue, so they can also give their inputs to the group, and I will also welcome that. So if anybody wants to speak about group insolvency, we have very eminent professionals here. I can read from the names, some of the persons uh, who are here. So I would definitely request, if somebody wants to give their input, most welcome. I think the issue is of the timing post lunch. That timing is always an issue. So in physical conferences, this is better. So definitely. So I would always recommend, if it can be made mandatory. So we have two cameras which have opened. I would definitely request, if you want to speak anything, Manish ji or Saurabh ji. Would you like to speak something about it?
No, sir, no questions.
Okay, no questions, no inputs. ये तो मैं I would recommend that to the institutes IPAs that they should mandatorily make it mandatory to have the cameras open
at least after post lunch sessions, so that the speaker also doesn't just waste his time, or if nobody is there to take the input, so he's keeping on speaking to a blank screen. So definitely there's some kind of, in next session I will definitely ask them that if this is there, then I'm coming. So that I would definitely request the CSIPA also to think over it and make some provisions regarding the cameras opening. So like so that the things are going to the right ears, and we get have an interactive kind of session and not only a monologue. Yeah.
Sir, I
So
think that this cross-border insolvency amendments, it will change the fortune for those companies which are MNC and having businesses outside India also. And
hmm,
it will also ease, RPs or liquidators' job to, liquidate those assets or take control of the assets which are located outside India. So
right.
it's a good move, I guess. And the amendments
Definitely.
are also, helpful.
Very right. Thank you. So thanks for your inputs. Let's take this up. Let's take cross-border insolvency now. So Prasad. So what these provisions these are also enabling provisions, I should say. So no definitive things have been brought in, but these are enabling provisions. So the provisions are like this. There is a provision for electronic portal for facilitating the procedure. Section 240B has been brought in, which says, notwithstanding anything to the contrary contained in the provisions of the code, the central government may, by notification, provide an electronic portal and the procedures related to insolvency and bankruptcy processes under this code, which shall be carried out on such electronic portal. So, first provision is about a portal, which is very nice. So basically, central government may bring in an electronic portal. So, wherein this provisions of so basically, this has been brought in, so that because it will make the things easier for uh, across the border insolvencies, etc. So for the RPs, if these are to be appointed, some company of abroad wants to see the things here. So whatever is going on, so they have the access to the portal and all. So, power to make the rules. Again, these are the main enabling provisions. 240C. Notwithstanding anything to the contrary contained in this code and the Companies Act, the central government may prescribe the manner and conditions for administering and conducting cross border insolvency proceedings under this code, including the process for recognition of the proceedings, granting relief, judicial cooperation, assistance, and coordination in connection with such proceedings for such class or classes of debtors or corporate debtors involving such countries or territories outside India as may be notified by the central government. So basically, central government will prescribe the rules. So where how the proceedings will be recognized, how the reliefs will be granted, what judicial cooperation, because courts of different countries will be required to be roped in. So because if the RP faces a problem, say in Singapore, so he has to approach that court of Singapore for getting cooperation, and so for getting the assistance, coordination, etc., with the from the corporate debtors situated there. So for this also, government has to enter into agreements with various countries, so wherein we can approach their courts. And also the governments should have to have agreements for recognition of our insolvency proceeding there. So if there is a resolution plan by somebody in India for some entity situated abroad, so so that plan has to be recognized by the authorities there. It has to be implementable there. So this all agreements will be required to be entered into by the governments. So reliefs, if they are required, somebody is happening there, some enforcement directorate of some foreign company has attached the assets. So there, so we'll be required to approach that authority for getting relief. And there may be many more things, like we keep on approaching, the courts for certain reliefs from many authorities. These are the part of our litigation. So all this will be required to be formalized with that country, and government will so I think will notify the countries accordingly with whom we'll have the arrangements. Maybe there are arrangements with some of the countries. So this is definitely going to be a very major step. So the rules made under this section, oh, kya hua? The rules made under this section may provide that any provisions of the code or the Companies Act shall apply with such exceptions, modifications, and adaptations as may be required to administer and implement the provisions of this section. Rules made thereunder, including designating one or more benches for dealing with the proceeding. So there may be designated bench for coordinating, this cross-border things. So that bench may coordinate with the judicial entities of other countries. So some kind of network will be devised by the government. So again, parliament has to approve. So basically that way. So expression corporate debtor shall also include the person incorporated with limited liability outside India. So basically the corporate debtors definition has been widened to include the person situated, the corporate debtor situated outside India. Yeah, next. Then comes about the insolvency professionals. So the provisions regarding the insolvency professionals. So we will take up that. I'll try to finish up early. So yeah, please. So basically, one provision is RP is not to continue as liquidator. There was a letter on which we all had a huge hue and cry that that letter, how it can be enforced by, and how IBBA can guide adjudicating authorities. But now they say, okay, it is in the code. Now take it. So now no RP can be a liquidator. So Amendment Act has provided that the RP shall not automatically continue to be liquidator where CRP fails or plan is rejected, not implemented. A separate appointment mechanism for liquidator has been introduced. Objective is to ensure that independence, neutrality, and avoid a conflict of interest. I have seen that, yes, though we are, most of us are opposing it, but to some extent it makes sense. To some extent, the RPs are getting encouraged to, resolve the corporate debtor instead of taking it to for liquidation. So they aspire to work more for resolution so that it doesn't go out of their hands. So practical impact is that fresh appointment process before NCLT and greater scrutiny of the RP conduct. Relevant provisions is section 34, appointment of liquidator, amended. So stricter timelines. So second thing is, one is appointment of liquidator, second is timelines. This is a major thing. So you all have read about it. So now even the claim verification and other process milestones have been reduced. AA so definitely has been given strict timelines for admission and plan approvals and liquidation approvals. But also the IPs are to prepare the memorandum fast, and also their stakeholder coordination they have to do. So disciplinary proceedings have been provided for certain failures. Some penalties or replacement has been specifically provided. So section 7, 9, 10, 12, and some other regulations in CRP liquidation. So you must have gone through all this in the previous session. So there is a very strong penalty and enforcement framework for the RPs. Amendment Act has strengthened the disciplinary and penal framework. So because there were issues before high courts, etc., regarding the constitution of the disciplinary committee. So they have formalized it through the code now. So basically that thing has also been taken care of now. Enhanced power have been granted to IBBI for monitoring and enforcement. Stricter action for concealment, delay, improper disclosures, and process violations. So consequences include penalty, suspension, cancellation of license, and disciplinary action. Relevant sections are section 70, 72, 73, 2008, etc. Yeah, आगे. So these are the provisions regarding the insolvency professionals. Other certain small amendments regarding IU, etc. We'll go through that also. So service provider definition has been changed. So now it includes the insolvency professional, IPA, information utility, registered valuers have been included. So and any other person falling within the category of person notified by central government for rendering services in relation to IBC under the code and is registered with the board. So these all are now in the definition of service provider. So basically, primarily valuers. So primarily it is for the valuers who have been included. Yeah. Yes. So monitoring committee. So as you must have read in earlier, so there is a monitoring committee now. So you must have gone through, discussed over it. So now there was no provision earlier that for monitoring committee. So now due to Jet Airways judgment, where Supreme Court has said that something should be brought in. So now monitoring committee is now there in the code, which was missing. So basically, the committee has to be constituted with RP or other IP or representative of the class of creditors and res RA, subject to such conditions and in such manner as may be specified. So that will come in the regulations. So already there, yeah, CRP regulations have some discussion. Papers are, yeah. Yes, Saurabh.
Sir, one question on this monitoring committee has been codified. Whether we are saying that it is expected that whatever would be the fees for monitoring committee chairman or the concerned person will be treated as CIRP expenses?
No, not at all. Basically, regarding the fees, there is always already a provision in the regulation that the COC is to fix the fees of the monitoring professional, and COC is to see that if the RP is to be appointed as the monitoring professional or some other person. So COC during the CRP in the last meeting, always we get it resolved there about the fees, and when the CRP concludes on the approval of the plan, so how can any cost incurred after that can be CRP cost? So it will be monitoring cost and will be borne by the RA only.
I got it, sir. Sir, when there is a deferred payment, mainly monetary committee has to make sure that all those milestones are achieved, and the same time, whatever the RA has committed to infuse the money, that should come to the basically to the escrow account. Now,
Right.
what happens is currently the fees for the fees is defined by the COC, but what happens is this fees has to be paid by RA. And this is a kind of a contractual agreement. So contractual agreement might be there. So tomorrow there can be a case wherein RA doesn't pay the fees to the RP, saying that whatever reason is there, and RP, and that might be a reason that RP says that you have not delivered the milestone, or you have not achieved the milestone, or you have not infused money. That's why you are in default, and a plan failure application that RP can file. But on that ground, RA can stop the payment of RP's fees or anything like that. So if it is in CIP expenses, then definitely there would be a pressure on the RA that okay, this have to be paid. Otherwise, if it is a contractual agreement and if it doesn't come, then RP's fees comes as a operational creditor kind of.
So that you are right, but as of now, there is no provision to make it a CRP cost. But I am myself in an NCLT for one of my matter where the RA is not paying the fees. So though the plan has been implemented, but due to certain distribution problems amongst the creditors, and not amongst the creditors, we can say that due to certain litigations pending, complete things have not been implemented. So now the RA says, there is nothing for me, only from me you are just in litigation with me for certain things, so I will not pay the fees like you are saying, because he has already got the CD. So these things happen. So here what I am doing is, then we have to bring, I have already I have gone to NCLT, that if the RA is not paying, let the creditors pay. So I have money of creditors with me which is yet to be distributed. So I will keep it on hold till, and also take directions from NCLT that yes, I should be allowed to take my fees and then distribute. So these things are there. So we have to see case to case. So some or the other mechanism we have to, devise.
Okay, my point is only that if this could have been made like CRP expensive, then it is, I mean, safer for a RP to make sure that his fees is secured.
I know. So there was one matter, it's a very big matter where plan has failed. I was appointed the liquidator. So the erstwhile monitoring professional, the litigation continued for maybe, for around 5 years. 5 years there was a litigation with the RA. So he was not paid the fees. So he filed an application before the court that now it should be called CRP cost. So that order is there. Yeah, so I have an order in my matter only. So he was not allowed because they say yes, it is to be paid by the RA only. So it cannot be CRP cost, it cannot be liquidation cost. So there is an order in my matter only, Amar Remedies matter. If you can see, you can see
Okay.
the so you can see the judgment in Amar Remedies. So Mr. Anil Goyal has filed that application for making it CRP cost, or liquidation cost for, and the amount was also handsome, around 2 crores.
Okay.
So the court has already ruled it cannot be CRP cost, or because the provision in the plan was that RA is to pay. So basically plan has failed, so fine. So nothing, and there is no remedy.
Thank you.
Yeah. Next, Prasad. So there is a small, we'll go through these discussion papers also. One is IU related. So this is, about the declaration of default. Some provisions have been brought in. So where the, how this will be dealt. So we'll just go through, have a glance on these provisions. So all these are parts of amendments, and I'm trying to cover each and everything in the amendments, in the code or regulations, whatever. So these are the proposals for IU. So section 214 and 215 deal with the obligations of an IU while providing core services, which, because IU will be very important now, because section 7 admission will be primarily based on the IU, a recording of the default in the IU, the NESL. So, and deal with procedure for submission and authentication of financial information. Section Chapter 5 of IBPI regulations, IU regulations go on the functioning of IUs. So, आगे चलो. So, IBPI has amended, IBC has been amended, this section 214 and 5 to provide greater clarity regarding manner of authentication of the financial information submitted to IUs. These amendments aim to strengthen the integrity, reliability, and evidentiary value of the IU records. So need for regulatory amendments. So in regulations, what is being done is, so section IBC has strengthened the framework by amending 214E to explicitly provide that such authentication shall be carried out in such manner as may be specified. So this amendment empowers IBBI to specify the regulations. So how they have specified, will just come into that. So 2153 says it is mandatory for operational creditor to submit financial information to the IU before filing application under section 9. So 2154 says that the corporate debtor or debtor, as the case may be, in respect of whom any information is submitted under this section, shall authenticate the information in such manner. So regulations are required for that also. So where corporate debtor or debtor does not respond to the information submitted to IU, like we are receiving, as you all must be going through daily, we receive some mails, that so and so default has been reported for this corporate debtor, so you please authenticate it. So for that they have provided. So but they say now it is in the law that such information shall be deemed to be authenticated in the manner or period. So in case we do not or the corporate debtor does not authenticate the default, that yes, this is right or wrong, or he disputes whatever, so the regulations need to provide how to go further. So we will see in the regulations how it is going. So section 7.5 clarify that where the record of default in regard to a financial debt owed to financial institution is recorded with the IU has been furnished with the application by the financial institution, such record shall be considered sufficient for the adjudicating authority to ascertain the existence of default. So now it is so important that admission only and only one thing is to be seen, that record of default is there. That is all, nothing else to be seen by the adjudicating authority for admission. So this is most important now about the record of the default. So aforesaid amendments seek to enforce the role of the IUs in ensuring accuracy and reliability of financial information, with placing an explicit obligation to the debtor to respond to authentication requests within specified timelines. So if the corporate debtor does not respond, it will be deemed to have been accepted. So, in light of the above statutory amendment and the past experience regarding the IU framework, certain gaps and ambiguous kitties have been identified, particularly in relation to treatment of cases where debtor does not respond the authentication request. The distinction between authenticated and non-authenticated information, and clarity regarding nature and evidentiary value of outputs issued by the IUs. So for this, what they are saying is, आगे. So proposed amendments are that alignment of the terminology. So like section 7.5 we have just studied. So existing provisions of IU regulations say financial creditor, which is bank, including in second schedule of RBI Act. It is observed that this terminology is narrower than definition provided under the code, which refers as financial institutions as defined in clause 3 or section 3 clause 14. So in order to align the regulatory framework with the code and to ensure consistency, it is proposed to amend regulation 21 and 21A to substitute the existing reference to financial creditor with financial institution as defined under clause 3 section 3 clause 14. Yeah, ऊपर करना थोड़ा. So this amendment is expected to remove the interpretational inconsistencies and align with applicability of the provisions. Then is information of dispute. It has been introduced as a distinct informational output. The existing framework primarily recognizes the record of default as the key output of the IUs. However, in practice, information may be authenticated, deemed to be authenticated in case of non-response by the debtor or disputed by the debtor. The section 2154 of the Amendment Act provides where the CD or debtor does not respond to the IU, information submitted to the IU in manner and period as has been specified, such information shall be deemed to be authenticated. In view of the above, it is proposed that IU shall record the status of authentication as authenticated and issue an ROD, record of default, in cases where, थोड़ा ऊपर ले लो ना प्रसाद, where the debtor confirms the default or the debtor does not respond. So in both the cases, it will be classified as authenticated, even if the corporate debtor does not authenticate the information within a prescribed time. So they say that information of dispute as a standard output. So the now earlier it was record of default. Now it is another thing is has been introduced which says information of dispute. So there will be another output from the IU which will say if there is a dispute, if the debtor disputes the information of default, so then it will be called information of dispute. So they say that now the proposed framework seeks to preserve the evidentiary value of record of default. However, so they have proposed that suitably they will amend and information of default will be supplemented. If there is a default, so it will say that this has been disputed. Another category is there. So one is authentication, another will be dispute. So basically, they will provide entire audit trail also of the dispute, that what all are the disputes. But I am worried that in case of Section 7 applications, what will happen? So because in Section 7 there is a judgment of Supreme Court in one of my matter only, extraterritoriality, which says that in Section 7 dispute is not to be considered. So once the adjudicating authority finds that it is not authenticated and there is an information of dispute, so how the adjudicating authority is going to handle it? So they may say that we have to go through this, we need to go see how it goes, because they will say it's not authenticated per se, it is disputed default. So let's see how it goes. So definitely, if there is a dispute here in the IU itself, so that would definitely, complicate again. Again, there will be delays in the admission. So even if there is a deemed default, so the deemed authentication, so they will dispute it, saying that they should be given an opportunity to now say something about it. So let us see how it goes. So then is rational forms have been rationalized. So this is only about the forms. आगे चलो. So public comments. Okay, fine. So basically, it's only about deemed authorization and deemed authentication and information of dispute. So these two things are the new concept which I wanted to discuss with you. आगे चल. So this is a record of default. So this is the information of dispute, wherein they will say that so and so. एक मिनट दिखाना ऊपर थोड़ा सा. Yes, name of the CD, unique debtor is so and so, default amount, date of default. नीचे आओ थोड़ा सा. Yes, that is authorized to issue this information and accordingly affixes design as per provision. So guidelines for tax. So this is definitely something to be looked upon. How it how it will affect our admission processes. This information of dispute and that dispute that deemed authentication. So I'm definitely a little concerned about this, that again some kind of vidarbha thing will come in with this information of dispute or deemed authentication. So we will see how it is taken up by the judiciary. आगे चलो. ठीक है. Record of default, if they dispute, it will be disputed, it will be shown like disputed, and information of dispute will be there. But in case it does not respond, or after 3 reminders, or there is he confirms the information of default, then it will show as an authenticated. So and will show the record of the default. So but the problem will arise where it is a dispute. So we'll see, but there is a Supreme Court judgment which says that dispute is not to be seen in Section 7. It is there in my case only, extraterritoriality, catalyst versus extraterritoriality. So definitely we'll see how it is taken up. आगे चलो. So then is pre-package. So pre-package though, so they have made certain amendments. So we'll just see cursory. So the corporate applicant shall, along with the application, furnish as may be specified. So the information to be so what they have done is, at least in the pre-package, they have made it mandatory that all the information for which we file section 19s, they have tried to include that he has to submit along with the application itself. So that because when he is voluntarily filing such application, so with that, so at least we should have this whatever information is available. So वो नीचे दिखा दो कौन कौन सी है. So they say और आगे. So yeah, proposed amendment is about the to list of documents. So they have not provided yet the list of documents. They say that that list of documents will be provided through circular, and forms will also be provided. Yeah, ठीक है. Okay, so it has been provided here. Information and document, copy of the declaration by majority directors, copy of special resolution, then proof of approval from financial creditors, details of IP, report of the RP, then audited financial statements for last 2 years, provisional statements, then the other authorized representatives have to furnish certain as a class of creditors. आगे चलना. Yes, आगे. Yes, next. That's it. So fine, these are all the informations to be provided along with pre-packaged application. Yeah. Next. Then is inspection and investigation. So like I was saying, for disciplinary committee, the clauses 63 and 64 of the amended act also amend section 217 and 218 dealing with complaints and investigations under the code, to substitute the words insolvency professional agency or insolvency professional or informational utility wherever they occur with the term service provider. So even the registered valuer will come under this disciplinary proceeding thing. So, as a common definition of service provider, it has been inserted. So, clause 66 of the Act has also amended 220 of the Code to clarify and expand the constitution and powers of the disciplinary committee, including the power to direct disgorgement of unlawful gains and provide for restitution to affected person. So, if there is a unlawful gain has been taken by some service provider, so it will have to be restituted to the maybe creditors or RA. So whosoever is the affected person. So there was earlier no such clause, only suspension was happening. Now all this have to be restituted to the restituted to the affected persons. So, and the constitution of disciplinary committee, as I was saying, so they can consist of one or more persons. Earlier it was being said that how come they get this power of only one person committee. So now there can be any persons, one or more, chairman can be there, whole time members, or any officers up to the rank of executive director. So definitions of service provider, fine, we have already gone through. Chalo aage. So basically amendments in the forms, etc., proposed amendments. So fine, this is all. Yeah, so mainly constitution. So these are the things, whole time members, etc. ये आगे चलो, service provider. So that all has come there. So then grievance and complaint handling procedure has also been amended. थोड़ा बड़ा करना है इसको. So clause 2 of the Amendment Act amends section 3 2 of the code by inserting a definition service provider. We have already seen. आगे चलो. So for थोड़ा ऊपर और ऊपर. So clause 63 amends section 217 to substitute the word so and so with service provider. So basically registered valuer again. So they have not included IPE. That is very strange in the service provider definition. Strange, but a relief, we can say. Yeah, to some extent. But एक second ऊपर आना. But when there is information insolvency professional, so when the IPE will be acting as IP, it will be covered. So, but if the IP is acting for support services, that will not be covered. But since the IP acts as an IP also, so there it will be covered under service provider, because IPs are covered here. So that way IP is also covered. So, in view of the changes in Amendment Act, the following is proposed as service provider. So, additionally, amendments may be made so and so. Proposed amendments क्या है नीचे आओ. Yes. So, basically, the proposed amendments नीचे है या annexure में. So, let us go there. So, what has been proposed is the words means an IPA, IP shall. So basically, so we say service provider is to be substituted. So the word shall have the same meaning as in clause 331A. Then form A, the words as substituted as the form by notified by the board. आगे. So this is all. So these are small, very small. आगे. Any other amendments? I think we have covered each and every amendment now. CRP and liquidation amendments were covered in the first session. So today all the amendments. So I would now request everyone, if there is any question, even in CRP liquidation processes or anywhere, so that you can please ask. So we can take up the questions regarding anything in this amendment. No questions? Then thank you very much. Madam, Anjali madam,
Yes, sir.
I have completed.
Okay. Participants, if there are any questions, kindly ask, otherwise we will conclude. Are there any questions? Sir, I think there are no questions. We can conclude now.
Thank you, Parminder ji. Thanks a lot.
Thank you so much, sir, for enlightening us with your experience and going through all the regulations in such a short span of time.
Thank you. Thank you, Bharti ji. Thank you. Thank you,
Thank you,
Budhyal
sir.
sahab.
Thank you.
Thank you, Saurabh
Thank
ji.
you very much, sir, for such a nice, knowledgeable, and interactive session.
Thank you, madam. Thank you. Thanks a lot,
Kindly
everyone.
share the material you have referred in the session.
Okay, sure, I'll share. Thank you, everyone. All the best. Thank you. Thank you, madam. Thanks. Thank you, Prasad.